All rise. The court is now in session. The Honorable Judge Mark Lemieux presiding.
Good morning. Please be seated. Good
morning.
All right. We're back on the record with State of New Jersey versus Paul Caneiro. It's indictment 19-02-0283. Can I have the appearances of counsel for the record?
Good morning, Your Honor. Assistant Prosecutor Nicole Wallace on behalf of the state.
Good morning, Judge Chris Decker, Assistant Prosecutor for the state.
Your Honor, Monica Masco on behalf of Mr. Paul Caneiro.
Yes, good morning.
All right. Good morning, everyone. Good morning, Mr. Caneiro. We were in the middle of the state summation, so we'll continue on with that now.
Thank you, Judge. Can I have the back right table, please? Thank you. Morning.
Morning.
We left off yesterday. I think we were at the video camera 5 from 19 Oxford. So I'm going to play that with respect to Mr. Caneiro's vehicle returning back from Colts Neck. Now, we've already seen 308 Green Grove, right? Down the driveway. White, Porsche Macan, black stripe, right? Passes 30 Tilton. We saw the flickering of the lights at 30 Tilton in the direction of 27 Tilton. So now, from 19 Oxford, from the rear, from a camera, as you can see here, we probably never expected to see what we saw. I mean, because when you look at the vantage point here, we're talking about a very small area, right? Where you capture just a portion of that 27 Tilton driveway. Because you remember from the daylight video, there's those trees there. But by the grace of God, we actually see that light right there. As you'll recall, remember when we saw the pictures of the garage, the 2 garage bays of 27 Tilton? There's 3 lights, like 3 sconces. One on the left, one in the middle between the doors, one on the right. Okay? So what we're looking at here, right here, kind of like when we saw that flash of fire previously, that's the light. Okay, so we're going to play that. So now we've seen the white Porsche Macan, the one being driven by one person and one person alone. The person coming back with the jeans, with the gloves, with the scarf, with the gun, with the barrel in it, not yet out of it, is pulled back in his own driveway. Now, when we talk about timing of the fire, remember we talked about Heather Kapp and Jonathan Harrington and when we can actually see the fire start. Now, we're going to see the video starts at 4:54. I'm going to speed it up a little bit because we know that that fire is going to start. It's now 4:56:32. And remember, these are just lights on the back of the house. Go over by the garage, right? What we're going to see, remember, we have 4 top windows when we look at the daytime. We got a window over here, we got a window here, window here, window here. And then that 4th window is right about here. The gas line and the basement window would be just barely outside of that frame. 4:57, in about 10 seconds, we see that gas-fed fire, right? Because that basement window is right next to the gas meter. There's accelerant and the gas line, right? We got the gas from the gas can, we got the accelerant, and then we have the gas line right next to it. So we know exactly when that fire takes off, right? Because it's going to flash here, right? And then we'll see from the next video, I believe it's the next video, when we look back at the driveway, you can see the flash, and you see the flash, but then it comes down, right? So that's the initial, the emanation, the beginning of that fire at 27 Tilton. So now we're going to see the same thing, 4:57, from the driveway view. We're going to see that flash, and then we're going to see it come down. Running it from 4:56 and 40 seconds. You see there's obviously some activity outside here, some lights on. But there we go. Well, this is going to be about 2 minutes before Mr. Caneiro pulls the Porsche Cayenne out of the garage. There, 4:57 and 10 seconds. That fire lights up the rear of 27 Tilton. We start to see Dr. Gould's back deck, right? Right here. And here is kind of like where that tree line is, and the driveway is right here. So think about, in some ways, how lucky we got to actually capture that driveway, right? I mean, there's no way, even if he set up the cameras at Dr. Gould's, that he ever would have realized that that camera is going to pick up his car at 2:07 and 4:08, and the fire started. It's just unfathomable to believe that we catch that little area here, right? See? Fire now. 4:57, 53. It flashed over for about 40 seconds, and then it subsides. Same way we saw it on camera 7, right? So now it's 4:59:50. We're looking at camera 5 again with that small area over here, right? The driveway. We're going to see the Cayenne being pulled out of the garage by Mr. Caneiro. Here we go. He's backing it out, because there's 2 cars there, right, by the one bay, and then he's got the opening by the garage, by the bay closest to Tilton Drive. So now he backs up, right, and then he pulls out forward the same way he pulled out at 2:07. So again, we're just looking at that car backing up, right? It's going to back up and essentially do a K-turn, right? It's the way you got to get out of that driveway, the way he's got to get that car out of that driveway. It's 5 o'clock and 5 seconds. The car's now heading out to Tilton. The car's going to park on Tilton Drive. And think about where that car parked on Tilton Drive, right? It actually, he pulls out. We don't see it on the video. He pulls out, and then he ultimately pulls it on the street right in the area of Cap and Harrington's house, right? So now, Miss Cap didn't specifically tell you that was Paul Caneiro's car, but that's Paul Caneiro's car that she saw in the street between Harrington's driveway and her house. Same place it was, remember, when Chris Sorrentino's running up to the front door. Hey, everybody's out of the house. Paul Caneiro's car. You just got to put it into context. Because sometimes when people watch things in the dark, They don't know what they're watching. Sometimes it takes a combination of evidence to kind of put it together. You know, they said a lot yesterday that we can't show you Paul Caneiro in the car. We can't show you Paul Caneiro in the house at 15 Willowbrook, right? We don't see him running down or out of the house at, you know, let's say 3:42, 3:43 in the morning in Colts Neck. But the only reason we can't show you that is because of him, right? He cut the power in Colts Neck. He cut his own cameras. So when we talk about did they find houses to the west on Tilden Drive, and you know they didn't look or they didn't document, he didn't show you any cameras from the west side of Tilden, the other way out, right? You saw all those maps and photos and everything. But like any camera that would have been over there that wasn't, would have shown us likely nothing because nobody goes that way. But it would have showed you the same exact things that you could have saw from the 4 cameras outside of 27 Tilton Drive. Like it's a little hard to understand how we can be blamed for not having more footage when the best footage, the best evidence would have been his own cameras that he chose to shut off. And the only reason, ladies and gentlemen, you shut those cameras off is because you don't want anyone to see what you're about to do, what you did, and what you did after you did. It's extremely telling. There is no good reason, zero, in this world why somebody shuts off their cameras at 1:28 and 1:31 and then leaves the house for 2 hours in the middle of the night. His car, he's driving. You know, we talk about being framed, right? And all the things that we didn't find. And we talked about how no matter who did it, they didn't leave a lot of evidence in the car, right? In the Porsche Macan. Like there's no blood except for the residue or the odor that's detected by the canine, Creed. Whoever was in that car, and I would submit to you that there is no doubt in this world that it was Mr. Caneiro. But the one little piece of evidence that was left in there that wouldn't have been all that noticeable, actually, Lieutenant Catalona didn't even seize it the first day when he searched the car. Remember when he takes the photos on the driveway? This was found the next day. It's a little piece of a black nitrile glove. Okay? Like, okay. Right? Consistent with the burnt gloves by the gas can, right? Consistent with all these gloves here. It's actually not that many, it's 6. But like if you're trying to frame someone, you're trying to set someone up, first of all, I said it already, you're probably going to try to leave some blood in that car, right? I mean, it makes sense. You're probably going to leave the barrel in the gun. It makes sense. You're probably going to put the backpack in the murder car, not in your wife's car. But if you're trying to set someone up, this is the best you can do. Leave a little piece of a broken glove, probably from when he tore it off and threw it in the back of the car, in the storage area, exactly where K9 Creed hit. I mean, that's not getting set up, ladies and gentlemen. That's just trying your best to not be sloppy, but still being just a little bit sloppy because of what he just did and the effect. No matter what you think of Mr. Caneiro, the effect that what he did to those little kids had to have had on him. Had to have. Now again, just point of reference. Maybe it's a little thing, maybe it's not. But the car pulling out at 207 here, out of the driveway, pulls out exactly the same way that he pulled. He pulled the Cayenne out at 5 o'clock. Maybe it's a little thing, maybe it's not. It's just another little thing that adds up with the gloves and the DNA and the ballistics and the cameras being on. And the cameras actually being on, showing you turning them off, right? I mean, that's important. Now, we talk about some of the defense witnesses, particularly now we referenced the camera, so let's talk about Dr. Gould here, okay? Dr. Gould, obviously friends with Mr. Caneiro. He told you that Mr. Caneiro, which you knew already, he's tech savvy, that's what he does for a living. He talked about, helping out with electricity and helping the guy who did the wiring with the lights and helping Keith out and all the work that Paul did at Keith's house. All the things that Keith relied upon, and part of the reason why he's collecting that salary from Square One and EcoStar. He told you about Paul being a gunsmith, and I'm not going to belabor that. I'm not going to reiterate the fact that I told you that he owned these guns lawfully. We're not asking you to hold that against him. But there's a reason you heard about the guns, because Dr. Gould told you he can take them apart. He's a gunsmith, he cleans them, he does all this stuff. Like, that's exactly consistent with ba, 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 ba. Ba. Even Dr. Gould eventually got curious, right? He eventually got curious. I asked him, did you watch him before you gave the videos, before you gave them to the police? And he hadn't. But at some point, he actually had to bring him back because not all the footage was on him, so he actually had to bring it back. I think it was Detective Melody. But I asked him, did you eventually watch it? And he was like, yeah. And he even saw Paul leaving, 2 a.m., Paul returning at 4 a.m. And I asked him, because we were looking at a photo, right? I showed him the photo of Sophia and Jesse and Jennifer and Keith. And I asked him about Keith's hair, and I asked him about Paul, who's got hair. Keith was bald. And then I asked him about Corey, just because, why not, right? Brought up Corey, right? They want to talk about Corey. What's Corey look like? We'll talk about why that's important later. I shouldn't have to prove that to you, ladies and gentlemen. He has nothing to do with this. Nothing.
Objection.
Come on up. You know what? It's overruled. It's definitely not an objectionable thing. Go ahead.
Again, all this goes to the fact is that they told you Mr. Caneiro was cooperative, how he talked to the police at the scene, and he was spoken to by several of the ocean patrolmen. We're really just trying to figure out what happened. Why is there a fire here? We're just trying to figure it out. And, he's telling them that he wakes up, he's sleeping, right? He's talking about, and even his daughter said it, that he was upstairs all night, not really being the family man that he was described as. He's just up in his bedroom from, 4:30 that day until all of a sudden a fire he wakes up to. It's just all inconsistent with the evidence that you're hearing in this case. Now, when we talk about the background, the financial motive, the build-up with Paul and Keith, again, I'm not standing here saying that it should have been enough, right? Murder doesn't always or rarely make sense. But, did we follow the evidence or did we ignore evidence? Did we try to see the communications, between Paul and Keith? Did we just stop after we heard that devastating phone call between Keith and Paul at 6:05 p.m. on November 19th, 2018? About 9 hours before the murder? No. You heard from Detective Maglorese, he read these messages, and I'm not gonna read them all for you. I believe you'll have them. But we need to understand kind of where this all starts. And you've all heard about April 2018. A little hard to read here, but what we're seeing is April 11th, Wednesday, April 11th, 2018. And this is basically Paul getting caught stealing from the trust, right? Keith was obviously trying to inquire. You can see Mr. Artigas and Mr. Weinstein are included because they're trying to figure it out. Yes, it was brought up yesterday, and it's true. There were times when the trust was not funded properly, right? There are times with businesses where maybe Keith didn't have the ability to throw $7,800 a quarter to the trust account. That happened. But what they didn't say to you is that, and I said it yesterday, he's got one job as the trustee. One job. This is not like managing real estate assets and all this kind of stuff. He's got a life insurance policy. Pay the premium. That's all he had to do. And listen, if Keith doesn't fund it, like in past years, if he doesn't give the $7,800 that quarter to the TD trust account, then no one is blaming Mr. Caneiro for not, he's not got to, no one is saying he has to pay it out of his own pocket. That's not the point. It's just, when the money comes to the TD trust account, that bank account, just click transfer. Like, think he can handle that. He knows his password. You heard it yesterday. The only time he ever forgot his password, of the 19 times when he transferred the money, not to Canada Life, but to himself, he never forgot his password, right? Never. It's like shutting off your cameras. It's like, Keith, I don't remember my password. Why do you think Keith's so frustrated? Keith's like, I'll even log in, just give me the password. But he can't give him the password. Take it for what it's worth. Take it for what it's worth. But Keith wanted to know where the hell the money was. And he couldn't get an answer. And he said, I don't know exactly what Mr. Paul Caneiro was saying on the other end, but we know by context that Keith is saying, you got 2 hours, let me know. You know, he's trying to be a little bit sympathetic, bless you. He's trying to be a little bit like flexible, right? Despite the months and months of thefts and where the hell is the money? He's giving him 2 hours. And he says, 8 o'clock, Paul. But you never heard anything about any other communication, right? There's no other communication in this world ever for the rest of time, except for Keith texting Paul at 3:14 through 3:18, because despite his anger and his frustration, justifiable frustration and anger, he still needs Paul. But here, what's interesting about this is, like, it's an admission that I took the money, right? It's an admission. Remember, he says I selected the wrong payee. He says it went to my daughter's student loans or whatever. Like, Paul's admitting that he stole from his brother, right? Sorry for all the confusion. I've had my head up my ass. But he's still not accepting responsibility, right? He's still saying that I accidentally took your money. I sent it to the wrong page. Now, we know that's not true, right? Because you saw the bank records. Detective Bassender came in here at length and testified about all this stuff. He didn't select the wrong page. He paid himself. And there's a lot of talk about him paying it back and all that stuff, but, like, the reality is he didn't pay it back. It just went to the business, and then Keith transferred it back to the trust account, and then he took it again. Because you will hear, if you want to call it paying back, if you want to say he reimbursed, whatever, were there times when he stole in the past and reimbursed? Sure. Does it make it right? I mean, he didn't tell Keith he was stealing before he paid it back. He didn't ask the beneficiaries, Jen, Jesse, and Sophia, obviously not Jesse and Sophia, but he didn't tell Jen, hey, I'm taking a loan, because that's what he would have needed to do, according to Mr. Cardenas, in order to take a loan. These are not loans. It's just straight up theft. And again, I said it yesterday, but when the judge ultimately charges you on the law and he reads to you about theft and misappropriation, and on the verdict sheet you're going to have some choices on theft, the allegation is $78,000. But playing with the money and looking at certain things and where certain things went in a family business, we're going to ask you to find between $500,000 and $75,000, not above $75,000. That's absolutely no issue whatsoever. But it's not the point. It's not about the money. It's about the trust. Like, think about 1999. Keith Caneiro decides, I want to create an irrevocable trust. And in order to do that, you need a trustee, right? And it's kind of ironic that it's so obvious what a trustee is, right? It's someone that you trust with your money and with the obligation of doing these things. But again, just transfer the money. Just click transfer. Send an e-bill or whatever the hell you have to do at TD Bank. But he knows how to do it because he's done it in the past. He knows how to transfer money because he transfers it to the TD Bank trust account to himself. It's not that complicated. But that trust ultimately, over time, it eroded. It started to go in a lot of different directions. And ultimately, you saw that trust was gone as of 6 o'clock on November 19th. But we need to look a little further. Look at the messages. And here is essentially, this is just like it's the same time, April 11, 2018. It's just a little more of a complete message, and it's maybe a little more of a direct message to Paul, or from Paul to Keith. And he says, what they're talking about is, yes, I went to bed early, I was shot, I figured out why there are payments missing. I selected the wrong payee from my list and made them to Pacific Lending, the servicer for student loans, instead of Pacific Life. Now, you saw the bank records and the summaries and the charts. That's not true. What he did was he made them to himself. He's just telling Keith that I made a mistake instead of saying I stole from you. I mean, he says, I changed the name of the account to the trust, so this will not happen again while this account is still open. Well, he had Canada Life in his bill pay for TD Bank a long time before April 11, 2018. We go on. I'm selling off some of my investments today, and once the transfer is completed, I will make a single payment plus interest to the trust policy. I'm sorry about that, and we'll make it right. Let me know when you create a new trust account with Bonnie, that's Jennifer's sister, so we can set up the direct deposit from payroll. I can pay the balance of the existing trust account and then close it. I didn't sleep most of the night trying to sort this out. There's nothing to sort out. He stole from his brother. That's what you need to sort out. Is it bothering him? I don't know. I don't know. It didn't bother him enough that, let's just assume they're correct, that he paid the money back in April, at the end of April. Let's just assume that's not like just a circular payment and not a reimbursement. Or let's assume it's a reimbursement. The reality, though, is as you're going to see in the next couple slides, and you heard the testimony. Obviously, you've all been paying attention. That has been very clear. Is that after this mishap, after I had my head up my ass, I'm going to make it right, et cetera, et cetera, et cetera, what he does is makes exactly 0 payments to Canada Life for the rest of 2019. What he does is just continue to take, culminating with the last theft, the last transfer from the trust account to himself on November 19th, 2018. Remorse? No. Just like preservation, like, let me just get Keith off my back for a little while, right? He's stupid. That's really what he's saying. Keith's not going to figure it out because he can't access the trust account, because that's the way it's supposed to be. It's really, Keith, I'm sorry. Keith was upset about all this, but sorry, Keith. Unfortunately, you don't have control anymore. He's got control. But it doesn't mean he can steal. It doesn't mean he can commingle. It doesn't mean he can take loans without the beneficiary's consent. Okay? He's talking about them changing the beneficiary. You heard some of that stuff. There was some talk about making Bonnie the trustee. I'm sure Keith wishes that actually happened, but it may not have been as easy as Mr. Cardenas said to you. Well, it's not that easy. So it never happened. I mean, I wish it did, because maybe we wouldn't be here. Okay? It didn't happen, but he knew that Keith was kind of done. But he continues. Paid nothing back. Doesn't make another transfer to Canada Life ever in the history of the world. And he tries now to cover his tracks by doctoring the bank records. Which, let's just remember this as we talked about thematically yesterday about how investigations work. Like, we're talking about bank records here that, like, we don't get, like, immediately, right? We don't just like go, hey, there's a trust account, give me the bank records. What happens is the detectives that are investigating this, Detective Bassender, who was doing the financial investigation, Detective Petrozzillo, and Detective Zerillo, they met with Steve Weinstein, right? He's the accountant for Paul, he's the accountant for Keith, he's the accountant for the businesses, and ultimately they sit down, and Weinstein's saying, yeah, Paul would send me the bank records, right, like an accountant. Because remember, part of the trust is like, there's like gift tax implications, and Weinstein said, I got to get the records so I can, because Keith was able to write, I don't understand it all. I'm not going to claim to. But basically, Keith had to account for gift payments. Basically, the transfer of the payroll was, he's allowed to account for it with the IRS and his taxes as like gifts, right? You have an allotment every year, whatever. And so Steve Weinstein, the accountant, had to like reconcile all that, right? And he's telling the detectives, yeah, Paul, Paul's making these payments to Caneiro Life. Here's the records, this and that. Ambassador's just gotten the records from TD Bank, and she's like, what the hell's going on here? I got the real TD Bank records, and then I got the ones that Weinstein got from Paul Caneiro, and they look different, right? Like, doctoring bank records is no different than shutting off your camera at 1:28 in the morning. It's just not. It's the same thing. It's just like hindering an investigation, okay? It's just trying to be smarter than everyone else. I would submit to you that you heard a lot of testimony about the special bond between Keith and Paul, and Keith was Paul's person and all this stuff. I don't know why I heard that so many times, but like I submit to you, based upon the evidence in this case, particularly this evidence, that he thought Keith was stupid. And he thought that this was his operation, despite Keith owning 90% of the business. Because we look here, we look at April, okay? And we see right here on April 9th, 2009, there is a transfer showing up from TD Bank to Canada Life Assurance, right? Okay, and now we're going to look over here at May. We're going to see on May 1, these are the records that Mr. Weinstein got, right? And it says 501, May 1st, TD Bank bill pay, $5,000, Canada Life Assurance Company. I don't know how well you can see that. But the first record that he ever gave to Steve Weinstein has the word assurance spelled wrong. ASSUARANCE. His first, literally, the first doctoring of records right here has the company name spelled wrong. Okay, let's keep going. So now we're looking to compare May, what we just talked about with the misspelling over here, to the real bank records from TD Bank. And what we're seeing is not that it went to Canada Life misspelled Assurance Company, 5,000. 5,000 went to TD Bank checking account ending in 3837. I'm sure you remember that that's Paul Caneiro's checking account at TD Bank. We go to June 1st of 2018. Fake records, real records. Here we see 618, Mr. Weinstein's looking at this, and he says, this time actually, Mr. Caneiro spelled assurance right, okay? But it shows that he transfers $7,500 to Canada Life, right? Weinstein takes a look at Detective Basseter's records over here, and he sees $7,500, same date, right, 6/18, June 18th, and it says, not Canada Life, but Paul Caneiro's bank account. And when we look here, we talk about funding, and I said it a few moments ago, but I don't know if you could do the math, but you look at all these transfers in, J. Martin payroll, EcoStar payroll. That's Keith's payroll going to the trust account. So, I mean, you could do the math. You're going to have this. And I don't know exactly if it adds up. But all we're saying is that any money that Keith put in that account for Canada Life was supposed to go to Canada Life. If it wasn't 7,800 and it was only 7,200, then put 7,200 in. Don't take it. Oh, well, he only gave me 7,200. He's $600 short, so I'll just take it myself. That doesn't work. Now we go to July. Again, we see on the fake records, well, this part's real. Jane Martin, EcoStar, all these transfers in. Periodically, the payroll, 500, 600, 500, 600, etc. And Mr. Caneiro allegedly pays $4,500 to Canada Life. But when we look at the real records, lo and behold, that $4,500 goes from the trust account to Paul Caneiro's account. August, we see on the left side, doctored records, right? And you see these check marks. It's actually Weinstein. He was like going through it, and like, as an accountant, he's been working with this business for years, and he knows their books and everything. But like, he's trusting Paul. Like he gave him the records. It shows it's going to Canada Life, right? Shows it's going to Canada Life. Shows it's going to Canada Life. But it's really going to Paul Caneiro. Paul Caneiro. Paul Caneiro. And Steve Weinstein's not getting the records from TD Bank. He has no interest in that account. He's relying on Paul Caneiro, the brother, the trustee, to provide the records. It's not until Keith, Jennifer, Jesse, and Sophia are dead that Steve Weinstein has any way to know that this is just a perpetration of fraud by Paul Caneiro on his brother. Had Keith had these records, and Steve had these records, and Ron Artigas had these records, there wouldn't have been all that scrambling on November 18, 2018. Keith, you heard it at 4 o'clock. Like, he's actually trying to give Paul the benefit of the doubt. Like, what's going on? I've been on the phone all day trying to figure it out with Canada Life. And the problem is that, like, Keith and Ron and Steve, like, they're not the trustee. Like, you might be the accountant, but it doesn't necessarily mean that they're going to give you the records. You heard at one point, I think, Artigas had to call and actually say he was Paul Caneiro because he was just trying to figure it out. But this is what's going on. This is what's going on. Again, just in August, we see all this money that's supposed to be going to Canada Life, and it's not. And is it a big deal? Is it a ton of money? No, it's not. But it's about trust. Did he trust him? Was he sick of him? No, they're both sick of each other. Keith's sick of getting stolen from, and Paul's sick of having to deal with, in his mind, this BS from Keith. As if, like, Keith shouldn't have just had some faith that the money he's setting aside for his kids is just going to be there. Now, if there were times when it wasn't funded, so be it. That's not Paul Caneiro's fault. It's probably not Keith Caneiro's fault either, but it is. I mean, he's the one funding it. But it doesn't make that right. And again, when we talk about a lot of the evidence that you heard recently with who Paul Caneiro is or who he was, it's just not consistent with the investigation. I'm not saying that his family or his friends knew about this. They didn't know he was doctoring bank records. They didn't know he was stealing from Keith. But it's the reality. It's the investigation. And it's not tunnel vision. It just is following the evidence. And the evidence is right here. Okay, little things. Bank records. Cameras getting shut off. DNA. Ballistics. Your niece's blood in your basement. It's easy to say, oh, well, DNA can't tell you how it got there. Well, we would have known how it was going to get there if he didn't shut the cameras off. Like, you don't need the DNA people to tell you that, you don't know how Sophia's blood got on there. I mean, we do. I mean, she did have 17 sharp force injuries, and his genes has blood all over. But again, the whole argument, like, we don't know how DNA gets there. We don't know how ballistics gets there. Well, in reality, we do. It's just that forensic scientists can't tell you. They're not involved. They get a pair of genes, right? You get a pair of jeans, and their job is to say, let's cut this, let's swab this, and let's see what we get. The investigation, the detectives, the evidence tells you how it got there. And the reason it's there, her hair on the scarf, God help me. Blood on the jeans, blood on the gloves. You know how it got there. You know how it got there. There's no explanation, okay? So to argue we don't know how it got there, the only person to blame for not knowing, or let's just say not knowing, we know. We just didn't see because we couldn't see him put the bag in the car. We couldn't see him take the clothes off and throw them underneath the pile. We couldn't see him starting the fire and then the other fire because those very cameras were shut off. If I say it once, if I say it 10 times, I'm sorry. But like when we look at where the cameras pointed and what they would have shown, it is so obvious why they were shut off. This is September. We're going to see that the tensions start to build in September. We got the doctored records, 1,000 going to Canada Life, 300 to Canada Life, 1,000 to Canada Life, 1,300 to Canada Life. And then we see the reality. Transfer to Paul's bank account, transfer to Paul's bank account, transfer to the joint bank account of Paul and Susan, which she had no idea, and transfer to Paul's bank account. This is all Paul Caneiro. Zero respect. And I know I said it once yesterday. I kick myself. I don't make sure it's clear. When he's taking, when I talk about this taking, this transfer from TD Trust to his own bank account or the joint bank account, he's not stealing from Keith. He's stealing from Jennifer, from Jesse, from Sophia. So, if anyone could do this to their family, to do what we saw in those horrific pictures, isn't it more likely that it's the guy who's already stealing from those very people? Like, I'm not saying that justifies it. I'm just saying that it's not unfathomable that he doesn't really have that special bond that you heard about. Like, you know, Sophia or Jesse's on his back in the pool, but he's stealing from them. He's stealing from their future. And he's hiding it. He's covering it up. But he got caught. He got caught. But he only got caught after the murders. No one really caught him except for April. He got caught, but he lied about it. The investigation into the fire of 27 children, into the murders at 15 Willowbrook, really just unveiled the fact that he was stealing from his brother and he was trying to cover it up. Talk about the escalation. These are Google Cloud messages from Keith to Paul and Paul to Keith, etc. Keith saying, this is total bullshit. You have time to email me when you need money for your insurance. Remember, he asked if he could put the $5,000 and change for the car insurance on the business, right? Because that wasn't normally covered by the business. And this is the conversation about that. Keith is saying, this is total bullshit. You have time to email me when you need money for your insurance, but you don't have time to follow up with me when I'm fucking dealing with an issue that affects our only large client, that being Doris Duke. Don't put your insurance on my card. I'll find my own fucking employee and put my own fucker advertisement out. Keith, question regarding the insurance payment. So now he's like, he's pissed because he's got to pay the insurance on the company, right? $5,000. Like, and I think at some point he says, I actually did it for you last year too. But basically, Keith's like, now Keith's kind of stepping back, and he's kind of going back into his, all right, let me try to help my brother, right? Let me see what I can do. And he's basically saying, why can't we pay it monthly, right? Why do we need to put $5,000 on the credit card? And Paul says, interestingly, despite the $60,000 of disposable income he has at that time frame, he's saying, because it's late and I don't have the cash right now, I had to pay for Katie's admissions, and I was not expecting that. And then Paul says, I went to pay it and the check bounced. And he says, I'm late and I received a cancellation notice. So they're not going to take that monthly payment, the insurance. They want the whole thing. They've already told him they're going to cancel his car insurance. So he's asking Keith for help, which is fine, But let's just not say that he's got all this money lying around, okay? Despite the renovations and all that stuff. Keith's trying to help him out, but he's saying, I'm done paying you anything for a salary. You are on your own. And Keith says, I just put $150K into this business. Your kids are done with college. I need to start saving for my kids' education. Unfortunately, no, he didn't. Unfortunately, he didn't have to save for his kids' education because they're never here. They're no longer here. Now they're talking about September 17th. They're talking about EcoStar, the sale, right? Listen, they both went back and forth. I'm not asking you to. We're not giving you the rosy version just because it sounds great. Okay, they're back and forth about EcoStar. But I think what you see from these messages and from the evidence you heard is ultimately that, like, Keith realized that, like, first of all, EcoStar wasn't making a lot of money. Okay, they're 50-50 in EcoStar, but EcoStar's like not really making a ton of money. Like, they got a lot of employees. They're doing pest control. It's not a cash cow. It's not $125,000 a month that they're getting from Doris Duke. Okay, like, that's money. Okay, like, that's even paying people. They're getting money from that. Except remember, Keith's getting 90, Paul's getting 10, because it's Keith's company. But they go back and forth with EcoStar. If we can get $850 for EcoStar versus, so he said he wanted to wait for $1 million. That's not exactly what he said. If we can get $850 for EcoStar versus $1 million at the end of the year, I'll wait. Otherwise, let's settle. I'm done. I want out. If I could get a decent job in the marketplace, I would just fucking walk. We know he was trying to do that. Now, Doris Duke, I'm going to talk about it in a minute. But, like, we're not saying that, like, he didn't want Doris Duke to renew. I mean, even at some of those proposals where it went from, like, $125,000 a month to, like, $96,000 a month, like, Keith will take that. And let's be clear, like, Keith could have a job and Square One could still exist. Like, he's not going to Doris Duke every day and doing the wiring and the IT work. Like, he's the boss. Like, they'll take the $95,000 a month if they're willing to do it. We'll talk about what Ms. Bassey said about that ultimately. But let's continue with EcoStar, because we know if I could get a decent job in the marketplace, I would just fucking walk. Now, we know from Ben Paolucci that, like, Keith is legitimately looking for jobs in the marketplace. The guy's got an MBA from Columbia. He's run a business for, like, 30 years. And the guy's got some qualifications. Ben's like, hey, there's probably some great jobs for you at AWS, like the cloud services of Amazon. And that's what Keith's doing, like, 3 nights before he dies. He's looking for jobs. You are my brother. I'll help you out as best I can, but I'm not doing this. I mean, if you could ever, obviously I never met Keith Caneiro or Jennifer or Jesse or Sophia. But, like, if you could ever kind of sum up what Keith Caneiro stood for, what the evidence in his case showed you, is you are my brother, and I'll help you out as best I can. But, like, you can't do it anymore. You can't carry it. Keith's got to worry. He's got young kids. They're not even in high school yet. They're not even close to college. They're trying to figure it out. Like, I got to worry about myself. You heard all the conversations, like, maybe I'll just, like, sell EcoStar, I'll put that money towards my mortgage. I need a big mortgage, but, like, he's thinking about just, like, dumping it in there, trying to get rid of a mortgage, so that even if he has to take a job for, like, less money, he'd be able to make it work. Like, he's thinking about that stuff, which is exactly what Mr. Paul Caneiro is not doing, okay? We continue. I know that, Paul, that is if Square One is a going concern. If it isn't, if I lose my only big client, we are done. Which is the reality. I mean, they lost Doris Duke, we know that, but they lost Doris Duke primarily, we know, it was done because of what happened here. They finished out December, but then the company, Doris Duke wasn't bringing them back. I would suspect, and I would submit to you, that Doris Duke was not bringing them back anyway. If you listen to Ms. Bassett's testimony, she wanted cheaper. She wanted a lot cheaper, and they did good work. He was good. Keith was good. The company, Rob Block, they were good. They did good work, but they were not cheap. $125,000 a month for a nonprofit. They were looking for that AWS style type treatment, right? They were looking for that cheaper, that cloud-based. Okay, it was where the times were going. And Keith and Paul, they're both smart. Keith knew where the market was going. I think you heard that. Like, everybody kind of knew that, like, the modern day IT stuff wasn't going to always be exactly the same. And kind of what they offered wasn't necessarily what everybody was looking for, especially for $125,000 a month. Keith, I need to start thinking about paying for my kids' college. We know that. And putting away money for retirement. I don't have insurance policies to pay me if I don't work. You heard that yesterday. I mean, Keith doesn't have that crutch, right? Paul does, but when you look at the income, the disability wasn't going to be enough for this guy. At least it wasn't going to be enough to satisfy the 3 Porsches and the Tiffany and the restoration hardware and the two trips to Colombia in 2018 and $800 whatever dollars for the Audi that he was paying, in addition to the 3 Porsches and the Jeep. This guy's got big expenses, and it's starting to crumble. That house of cards that Ms. Wallace told you about in opening, we stand by that based upon the evidence in this case. We're not going to over-dramatize it, but, like, it's reality. You have that, so figure out a way to restructure things to live within that. He's trying to, like, be like Paul. Cut down the expenses, like, deal with it, plan for the future, but he doesn't want to do that. I'll do what I need to do to ensure my kids will be able to afford college without giving them loans, which is exactly what you did. Hey, can you check with Block to see where he is with that information? So this is November 5th. So this is like the build-up to Keith having to go meet with Doris Duke and Guli Basu, right? So basically, Keith's trying to get together the information, because they're asking questions and stuff, so he can go and present to Doris Duke and say, like, here's what I got, here are the options. You saw those 3 emails with the proposals. The 6-year option with 4 years or 2 years, like, if I know anything based on what Ms. Basu said and the evidence in this case, if they were going to get that contract back from Doris Duke, maybe it was for a year. Maybe. That woman who testified in here was not signing a 6-year contract with Square One. I think that if you recall that testimony, that's abundantly clear. You're asking Rob Block, who you heard from. I also want to see if we can do something to get cash for EcoStar. So he's bringing it up again, right? Like, he wants to get rid of EcoStar. I mean, he's not going to sell it for $200,000, but if he gets a decent number, he wants out. It's just aggravation. In case Duke doesn't renew, okay, Paul says rest, we can talk tomorrow. Keith, I'm thinking that if shit really goes sideways, I cash out my 401k and insurance and get rid of my mortgage. I just said that. That's exactly what he was looking to do. Even if I lose money doing that. So he's not really concerned. He just wants to be able to get a job. Like, he just wants a quote unquote, like, this is not to disparage the family, basically. He just wants to go to work every day and actually maybe report to someone who's responsible and just kind of like do his job and go home. Get a paycheck and go home. Not have to worry about payroll and where it's going and whether it's getting to where it's supposed to be going. Like, he wants a little more simplicity in life, it seems like. Paul says relax. That's what he always seems to say. Yes, he's calm. Is he level-headed? I submit he's not. But he's calm, right? Because he's trying to keep Keith at bay because he doesn't want Keith digging. Okay? He doesn't want him digging because when Keith digs, bad things happen for Paul Caneiro, and ultimately, bad things happen for Keith and his family. Let me see if we can get a call going with the people interested in EcoStar tomorrow. Even if it's 900, I would do it. Paul, fucking relax. He doesn't want to get rid of the business because, let's just say 800, right? He gets 400,000, right? He owes money to the IRS. He owes money to credit cards and blah, 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 blah. Like, that money is like, he's better off with an EcoStar credit card than he is with 400,000. That's just going to go like this. It's going to be gone in weeks. Okay, so understand that. Understand the expenses. It's not just like, sounds great, right? Hey, I sell a business, I get 4, you get 4. Okay, but, you know, there's money that needs to go elsewhere immediately. So it's not going to get the job done. He needs that piggy bank. Go to sleep. We don't need to do this. We don't need to do this tomorrow. We don't know. Paul says we don't know what the future is. Well, that never a truer statement was made. And Paul Caneiro says we don't know what the future is. I know what the future is, Keith says. They're going to cut to 2 people. I'm going to have to kill the new guy that we just hired. When he says kill, he's talking about fire the guy they just hired. Again, 90-10. Doris Duke. I'll keep it brief. You saw that Keith, I think it was November 13th, he meets with Gouli Basu and Peter Simmons, who's like the CEO or LO or whatever it is. And he basically says, all right, after the meeting, like they discuss, Gouli says they discuss finance and like we want it cheaper, we want it less. They don't want less people. They don't want Square One to go from 3 to 2 techs that are in the office every day. They just want it cheaper. And the only way Keith can really make it cheaper in his mind is to go to having 2 people go there every day as opposed to 3, because obviously it now brings his costs down, so that they can go to like 96 from 125, right? The salary savings. But like when you heard Ms. Basu testify, they got those 3 proposals, and she said, we didn't make a decision yet, but I would submit to you based upon her testimony, that salary savings was not going to get the job done. And maybe it's easier because now we're getting pretty close to 2019. Maybe it's easy to just run out that contract. Because remember, the contract wasn't actually expiring. It just, they had an option to cancel, that is, Duke had an option to cancel the contract at the end of 2018. So, like, it could have gone another year. But that wouldn't have changed that Keith's applying for jobs and all those different things that he's trying to do. And he's trying to sell EcoStar. Like, he wants to just be like one of us who just goes to work every day and doesn't have to deal with like the pressures and the BS, so to speak, of running a business. Now, again, I'm not going to belabor it. You heard the testimony. You've seen the charts. You're going to have them. You know, they made it sound like, okay, these are his expenses. This is what he makes. And he's going to get more in a little while from disability. Okay? The reality is, when you look at the bank records, when he's taking money from the trust, it's because he's in the negative. You know, that insurance check, it bounced. Like, I'm not saying if he thought rationally, he couldn't have figured it out. But this is a guy who's got 3 Porsches in the driveway. Like, he's not looking to cut his expenses. He doesn't want to do that. Overdrafts, return payments, withdrawals during that time. Now, September 2018, Paul's financial issues that we've seen in this case, and you'll have 9-3. Paul complains about not being properly reimbursed for his cars. Like, he's going to Tiffany Rivera, the business manager, he's saying, you know, ever since we got the different car, I think it was the Caneiro, whatever it was, I think the reimbursables are wrong. So it's like, he's complaining that, like, he's not getting enough money for the car reimbursables, as if, like, he should even be getting them as a 10% owner in the business. September 11th, he received a failed payment notice for Susan Caneiro's iPhone. Basically, like, he didn't pay the bill. 9/11, Paul considers taking out another, and you heard about several, 401k loans from Susan Caneiro. Now, she doesn't know. 9/12, he receives a missed Audi payment notice. 9/14 to 9/16, he gets an email regarding that Allstate payment. That's the one for the car insurance. Again, September 16th, Paul asked Keith if he could put his auto insurance on the company card. Saw that. September, it's not going well. Showed that he struggles all the way to the end until that final withdrawal, final theft of $1,200 from the trust account. when his balance was in the negative. Are we ignoring things, or are we following the evidence? Let's look at, first we'll just, the trust. I think we've talked about the trust enough. Obviously, the trust, he's a contingent beneficiary. Corey is as well. Paul knew, Corey didn't. Just talk about the trust in the context of how Mr. Caneiro looked at it.
Yep. And that's what that trust is going to let you do, because the trust account is going to give us access to everything. It allows, basically unlocks all the other stuff. Getting everything back, sorted out.
Like, this is January of 2019, he's talking to his wife. He's basically explaining the trust and how it unlocks other stuff and investments or God knows what. But like, Keith, Jennifer, Jesse, and Sophia are dead, and he's talking about the trust account. Like, family man, loves his brother, special bond. Keith's dead. This is the conversation.
Yep. And that's what that trust is going to.
2018, January 2nd takes 1,000. January 10th takes 500. 22nd takes 2,500. February takes 2,200. May takes 5,000. Prior to taking this, he's in the negative. May 15th, he takes a 401k distribution of $43,000. June 18th, he takes $7,500 from the TD Trust account to his own account, and $43 went fast because his balance on June 18th, prior to taking this money, is back down to $4,000. July, he takes $4,500. August 3rd, takes $4,000. Prior to him taking the $4,000 from the TD Trust account, he's in the negative. And then he couldn't make his mortgage payment. August 17th, takes $2,500. His balance is once again low prior to taking the money. August 28th, he takes $1,000. Prior to taking this, his balance is in the negative. He needs this trust account, ladies and gentlemen. It's not always massive amounts of money, but it's every time he can't pay something else, he goes, click, and he just takes it from Keith. Not alone, it's just theft. Repeated theft. September 4th, he takes 1,000. Prior to this, his balance was low. September 4th, he takes 300. Prior to taking this, the balance was $9. September 7th, makes it $5,200 and change payment to Allstate, but he's way in the negative. Allstate payment is returned for insufficient funds. Obviously, there wasn't enough money there to make that payment. That's why he had to ask Keith. 9/10, he makes a $765 payment for the Audi, but he's in the negative. 9/11, Audi payment is returned, insufficient funds. The next couple days, there's 5 overdraft fees. September 12th, transfers $2,500 from the EcoStar operating account to get out of the negative. September 13th, transferred $500 from EcoStar. Sorry, that I just said that. 9/14, pays $1,265 IRS bill and is in the negative again. September 17th, takes $1,300. Prior to that, he's in the negative, and then he's back in the negative on the same day. September 18th, transfers $1,000 from EcoStar. It's not necessarily his money. September 25th to 26th, receives 2 disability payments. October, balances in the negative again on October 3rd. The next day, he takes $1,500. The next day, he's back in the negative. October 9th, he takes $2,000. October 9th, balance is back in the negative. There's an overdraft fee for insufficient funds on Discovery student loan. October 10th, he makes a mobile deposit of $4,000. October 15th, he takes $1,200. On the 17th, he's back in the negative. The 18th, he transfers $700 from the EcoStar operating account. So why would he not want to sell EcoStar? Is it not clear by looking at this? Because if EcoStar's gone, yeah, he has that $400,000 or whatever that dissipates really quickly. But he can't just transfer every time he needs money. 10/24, he receives a disability payment. 10/29, he takes 2,000. November 8th, he takes 1,000. November 15th, he takes 1,300. Prior to that, the balance was low. The next day, he's in the negative. And he stays there until the final transfer from the trust on November 19th, 2018. The same day Keith's trying to figure it out, he is stealing $1,200 from the TD trustee. We talked about the numbers, ladies and gentlemen. One of the, like we said with the theft, one of the options that you'll have when I submit you find Mr. Caneiro guilty of theft, there's over 75, and then there's like 500 or 75,000. Conservatively, there's no doubt we'll ask you to find in that range. Continue to follow the evidence. Now we get to, now we know Mr. Caneiro stole $1,200 from his brother. Keith doesn't know this on November 19th, 2018. But now we go to these phone calls, the final build-up, so to speak, of what is going to happen in about just under 12 hours. Keith Caneiro, this is the beginning of his final 12 hours on this earth.
Counter Life is telling me they haven't been receiving money except in April. That doesn't make any sense. Counter Life is saying they haven't received money since April. I know it's not true. I need you to send me the statement ASAP because I'm on the phone with them all day already. I need to access the money. Fine. Do you have it scanned somewhere? Do you have it scanned in Inferno? Can I log into it and grab it? Do you have the online access? I'll just go online and see it. You don't have the online access? If you could just see a way to send me the password, and I'll do the research myself. Thanks.
Now, 6:05, a couple hours later. Keith tried Paul, so then he tries the house. He speaks to Susan briefly and says, I need to talk to Keith. And I need to talk to Paul. Now Paul Caneiro calls back his brother.
Hey, Steve, how are you? Sorry to call on the house line. I'm looking for Paul. I know he's sleeping, but I need to talk to him. Yeah, definitely. Thanks. Yeah, please. Call me on my mobile. Thanks. Yeah, thanks. Bye. Hey, I just spent the last hour and a half on the phone with the insurance company. They're saying they haven't received any money, and that they took a loan against my account, and they're taking another one in October, which is just in October. I need to know, show me where you're sending the checks in online. You're writing them out online. I need to know where they're going. I need you to wake up, Paul, and do it. Short of you being dead, I need to see your stuff. You need to log into your account then. You log into the TV account. Give me the login to the TV account. Your TV account, you don't know yours? You don't know your TV login. Go find it and give it to me. I need to see it now, Paul. I need to see it. I need to see it now. I need it. I understand, Paul. I understand that. I just spent half the day. Paul, I'm telling you. I need it. I need it. I need it. Give me the fucking login, Paul. Give me the login, Paul. Paul, just give me the login so I can see where the money went. They get on your computer and tell me where the money went. Paul, somebody else could read it to you there. I need to know where that money went. What's a little while, Paul? I understand you're saying you need to wake the fuck up, Paul. Paul, I'm telling you, I just spent half the day looking for this. I need to know where it went. Paul. Paul. Are you sure it went to the right place this time? You have cash checks? You have cash checks? Paul. I hear what you're saying. Paul, I'm worried. I need to know where it went. All right, an hour or two. An hour or two. An hour or two, Paul. That means by 8 o'clock.
He believed the excuse from April about paying the wrong pay accidentally. He still trusts his brother. I need to know it went to the right place this time, right? After that conversation, I said it before. Does Keith's phone, does the defendant's phone, any video or anything show that Keith got a call back? He got an email? He got an answer? Mr. Caneiro looked at it? There's nothing. 1 to 2 hours. 8 o'clock, Paul. Nothing. He's up in his room. Paul Caneiro's up in his room. Playing with a razor blade. 6 hours. Nothing. He does nothing to rectify it. No text, no call. He can't he doesn't pay it back, right? He can't do that. He doesn't have the money to do that. Just admit it. Admit it, and we're not here. Admit it to your brother. Do something about it. And we're not here. You're not here. Keith, Jennifer, Jesse, and Sophia are. Terrible reason to kill a whole family. But only one person has any reason to kill that family, and it's him. to the negative. And when we talk about Miss Wallace, and I won't belabor, and Miss Wallace said it best in openings when she talks about those 3 income streams that Mr. Caneiro has. He's got the payroll, right? He's getting paid. His family, he and his family are getting paid by Square One and EcoStar. He's got the disability, and then he's got the piggy bank taken from Keith. Those are the steady income streams in 17 and 18. Okay? If they get rid of EcoStar, he doesn't have that. If Miss Basu and Peter Simmons from Doris Duke say, you got a year or you don't have anything, we're moving on. He's got nothing but the disability. And it's not enough for the way he lives. It's just not enough. And he's not willing to make it work. Also, though, when we talk about motive, right, we know there's that $1.5 million from the trust account, right? And you really haven't heard us standing here, Ms. Wallace explained it in opening. We're not saying that, like, he killed Jesse, Sophia, Jennifer, and Keith for $1.5 million. That's part of it. I'd submit to you, ladies and gentlemen, that had to be the only reason that he went back inside that house or went inside that house. Because that's gotta be the motivation to go in and get rid of Jennifer, Jesse, and Sophia. He killed his brother. I mean, again, I said it yesterday, not justifying, but saying he purposely, knowingly killed his brother. And it doesn't make it right. None of this makes anything right. But, like, that's why you heard all for 5 weeks, you heard about why it's so believable how he could kill his brother. It's so believable. Just understand the context and the build-up and the jealousy and the, I'm not doing this for you, Keith, anymore. I'm not coming over and fixing this, fixing that. You can understand that. But the only reason, after you execute your brother, that you make that conscious decision to walk inside that house, that dark house, betray that trust, is because the money's inside, right? The only way he gets anything, he just doesn't get anything other than, he doesn't even get anything from the businesses. Presumably it would have gone to Jennifer and the family, right? They're 50%, they're 90%. Only motivation to go in there is money. Now, does it make sense? I don't know. I struggle. Why? Why would he kill Jennifer, Jesse, and Sophia? Why? The only thing you could think is that it's $1.5 million reasons why. He's already killed his brother. He's going the rest of the way because he knows it's how he benefits. But assume for 1 second ago, maybe Jennifer came out and caught him, and that's why he had to do what he had to do, right? Jennifer walked out because she heard the gunshots, runs back inside, game on, right? Kids come down because they hear the commotion. I don't know what the answer is, to be quite frank with you. I don't know. I can't get inside Mr. Caneiro's house. All I know is that he did it. He did it. Because the evidence tells you he did it. I wish I could come up with a reason. I have no reason. I could never come up with a reason to tell you why he did what he did to the kids. I don't know what to tell you. But he did it. He did it. Because the evidence tells you he did it. This shutting cameras off and DNA transfer, and God only knows why my niece's and nephew's DNA is on my jeans in my basement. You know, why would I lead police there? Maybe he tried to destroy it and he just didn't do a good job. But he did it. But he also, to kind of close that loop, what Miss Wallace told you was it was less about what he stood to gain and more about what he stood to lose, like the desperation and the frustration and the, Keith, I'm not doing this anymore. I'm sick of you owning 90%. Because he's not just losing the 3 steady streams, the theft, the disability, and the payroll. He's losing health insurance. He's losing these credit cards, $143,000 in 17, $120,000 in 2018. Man, that's not $50,000 of disposable income. That's reality. So he stood to lose. They told you the motive isn't good and all that kind of stuff, but it's good for Corey, but it's not good for Paul. But like for Paul, it's not just about that he stood to gain 50%. It's also about all that stuff that he would have lost had Keith's plans kind of come full circle and had Keith realized that his brother is stealing from him. No, Keith has an MBA. Paul steals from Keith. Again, understand when we talk about why he did what he did and why I submit to you that the evidence is going to tell you that the only verdicts in this case will be guilty. The finances is not something that just played itself out. That's not why he was arrested. That's not why he was charged with murders. He was charged with murders because early on, we're talking before Bodie, we're talking before StarMix, right? You know, we're not, all that stuff that was sent and Miss Danielle Reed came in here and testified. Like, before that, the DNA went to the state police lab, right? And we got results, right? We got Sophia's DNA on the knife, on the handle, right? And we got Sophia's DNA on the jeans. We're talking about that random match probability. I'd submit to you that random match probability, likelihood ratios, they're just two different ways to explain the importance of DNA. I mean, when you're going to say that like 49 billion is not like probative, that it's actually the defendant's blood on those genes or DNA on those genes, like you're trying hard to justify what looks really bad. Okay? But remember, we had that DNA before we had all the other DNA. We had DNA. You heard it. The first witness, Chris Simkoviak, the guy actually said it right. And then we also had Chris Clayton with the ballistics. You know, because think about what that means. So the financial stuff it's a buildup, right? It's a process, getting records and trying to understand the context of two guys who own businesses together, you know, and they have a lot of expenses, and they have clients, and they have to figure it out. That's why we had to meet with the accountant and the insurance guy. You know, they're sophisticated insurance people. I mean, he's got 3 disability insurance policies. Like, I didn't even know that was a thing. Just follow the evidence. And again, when we talk about the finance and the motive and stuff like that, and whether or not it justifies anything, like, think about the fact that within hours of the investigation, Lieutenant Catalona searches the Porsche Cayenne, Susan Carroll's car, at the Ocean Township Police Department. The car he never thought he was going to have to drive to the police department. Never thought it was going to be searched. It's the barrel. Like, I don't care how much he loves the backpack. I don't care how much it's an extension of his wallet. But you want to have some stuff in your backpack? Sure, okay. It's actually a tactical backpack. I work with a lot of detectives who carry basically the same bag. And they have stuff in there, okay? But like, that? Silencers over there? I'm not going to belabor it. He didn't use it. We told you that. We told you he didn't use a silencer. It's interesting to know why he's got a silencer in his backpack. It's because, really, in reality, he doesn't want it to be with all the guns that are lawfully registered, right? And the rifles and stuff, the gun cleaning supplies, and the you know, the hanging targets, practice shooting. Because the silencer looks bad. Like, there's no reason to have a silencer. He didn't use it. He didn't need it. We know it. Kapoor heard it from 2 miles away, right? The gunshots. Remember, he's fleeing that scene, thinking to himself, man, we're in Colts Neck. It's wide open. Somebody's going to hear that. Like, you got to assume someone's calling 911 when there's 6 gunshots in the middle of the night. I mean, you have to. That's why he's sloppy. That's why he got the hell out of there quickly. And that's why he went back. But, like, before we talk about motive, ladies and gentlemen, why is he taking this out of the 6th hour? If you're getting set up You're not taking this out. Now, Chris Clayton, he figured it out. It wasn't hard for him to figure it out. He test-fired this barrel. He test-fired the barrel that was in the stick sour as they found it in the locked metal cabinet in his basement. He figured it out. The barrel from the gun that was in the cabinet, just in case they found it, that barrel doesn't match. This isn't like, oh, they're both Sig Sauers, et cetera, like all the ammunition's gonna match. No, it's not like that. That's not what Clayton told you. One Sig Sauer could have been manufactured seconds after the one before it. And the ballistics will never match. Bullets, gun, they only link. Bullet matches to one barrel. One barrel because it's fired out of here. Let's just keep that in context. This, ladies and gentlemen, this killed Keith Caneiro. This likely shot Jesse Caneiro. You heard the testimony. Dr. Thomas said she couldn't conclusively say it, but it appeared to display patterns consistent with the gunshot wound through the chin, like a graze wound. And you know we found the bullet in the kitchen a few feet away from where Jesse was. So, context, investigation, step. Build up. Not zeroing in. You know, if this didn't match, or the gun didn't match the projectiles, I don't know, do we maybe look somewhere else? If the DNA didn't come back to him, and it didn't come back to his niece in the basement, do we look somewhere else? Yes. But like, should we be stupid? Or should we follow the evidence? Again, we're talking about the backpack. We just talked about the barrel was in there. He's got savings bonds. He's got Colombian currency. He's got a driver's license. He's got his passport. You saw the pictures. It's here. His passport. The Audi key. Got every card in his wallet, right? Including, it's not in his wallet like in his pants. It's in a backpack in his backyard, in his back seat. Like, how is someone else getting this driver's license into that backpack with the barrel and the silencer and the passport and the money and the savings bonds? You're going to set him up. You picked the wrong car. It doesn't make any sense. You're putting that stuff in the Macan, no doubt, if you're trying to set someone up. Not in this car. This is where they found the barrel. It's in a pinch bag, you see. It's the barrel. Paper towels. And interestingly, too, when you look at those paper towels, when you look at the photos from where the DNA is found with the jeans and the scarf and the shirt, all that kind of stuff, you see paper towels. Like he wraps this in paper towels. The same way there was paper towels in that pile. Silencer. This is where we found the gun. Right here. Ammunition right here. Fiocchi's down there. You know, after we find the barrel, and after we find the gun, then we get some DNA results, and it's starting to look like we're not zeroing in on the wrong guy, right? Just following the evidence. This is where it's found. This is the jeans, and there's one pair of jeans. There's one pair of jeans. Obviously, look at the tearing on the jeans. I mean, there's a portion of these jeans that are missing. We talked about it yesterday. This is what's in the bag, because that bag was sent to the state police for testing too. I mean, they saw that. They didn't say these are different jeans, let's test them. They saw that they were one pair of jeans. It's the blood. Blood in the gloves right here. Talk about transfer. You want to talk about transfer? Like, could some of that blood got onto the glove? The blood from the jeans got onto the glove? Of course. It's right there. But could there have already been blood on the gloves? Like, why are they in this pile? because he's using these gloves to try not to leave DNA, to try not to leave fingerprints. Okay, like, this is like, there's a lot of questions. Did Detective vote? Did he check that door? Did he swab it? There's blood everywhere. There's not blood everywhere. You're going to have all the photos. It's a fire scene. There's a bunch of blood in the kitchen, which Detective Courtroom explained about. He's an expert in blood spatter analysis. But there's not a lot of blood in the kitchen, and we get criticized because he only swabbed 4 areas. But like, you can't swab every single place where there's blood. State police, I think you heard, they're not going to test it all for sure. That's for sure. They took an area here, an area here, an area there, and an area here. And you know what you found? Sophia. You found Jesse's by the handprint, right? Very visible handprint on the south side of the kitchen island. And then you go around to where Jesse's found. And then, I said it yesterday, but you find that blood on the kick plate on the bottom, the stainless steel cabinets. And man, we really just figured it would be Jesse's, right? And maybe it took them so long because they were just trying to piece this together. Like, what can we do to kind of explain one day to a jury what happened in that kitchen? And lo and behold, that testing, that area is Jesse. We know they found him dead. He's lying on the ground. He's up against the cabinet. He's got the blood there. But who would have thought that Sophia's blood's there? Like, she's trying to help her brother. She's bleeding. There's no other explanation other than like, Jesse. And then for some reason, she's bleeding in the kitchen. And she decides, I'm sure she didn't want to decide, to run away. And she goes upstairs. And that's where she's left. That's where she's incapacitated to the extent that she can't get the hell out of that house. I'd submit to you that that's that stab wound through the face into the brain. And that's why she had all the smoke. She had all the soot. She was 49% carboxyhemoglobin. Dr. Zane told you, and I'm not going to belabor this, you know she suffered. Horrible. 10% you might get nauseous, right? 40% you could die. 49% is what she had. Her cause of death was not just, like, it wasn't, be clear, what Dr. Zane told you is the cause of death. It wasn't a contributing cause. It was the cause of death was sharp force injuries and smoke inhalation. The special bond with Jesse. Jesse didn't have the stab wound to his face. Passport, bag, all his credit cards. The knife he had, the bag. Fleer. I don't know. I mean, again, the cameras are shut off, so I don't know if he's walking around like this with a spare phone that's in. He's got a ton of spare phones this big. I don't know if he used it. I can't tell you. We lost the ability to tell you certain things because of the choices that the defendant made to make it difficult or simply impossible to see what happened. The Audi key, some other keys, some college applications. This Restrepo told you about that. Her daughter's college applications. Passport. Caneiro. It kind of leads you to the question that I'm sure, I suspect you're all asking is like, where was Paul Caneiro going to go? Like, there's no other explanation. And I don't know that. I'm not saying he had a plan. He didn't really have a lot of time to have a plan. He comes home at 4:08, packs the backpack, has to figure out how to set the fire, get the clothes in the corner, take them off, switch clothes, make sure I don't have shoes on because I want to make it look like I'm sleeping. But like, that bag, whether he carries it all the time, it doesn't always have that stuff in there. Like, there's no way, and we know that the barrel was just used in Colts Neck, I don't know, like an hour later, or hour earlier, right? That barrel was used in Colts Neck. obviously before he pulled the car out of the garage, right? 5 o'clock. This barrel is used at like 3:26, let's say, Dennis report, right? So like, no matter what he had in that bag normally, he didn't normally have this in the bag. And I bet he didn't normally have the silencer in the bag. And I bet he didn't normally have the passport in the bag. And I bet he didn't have like a ton. Of savings bonds. Caitlin and Marissa Caneiro. Like, he's got a safe in the garage. Like that big black safe you saw spinning. Like, what the hell are these doing in the backpack? Listen, not the biggest piece of evidence, but like, think about it. What's he thinking? He's thinking that, like, listen, if the cops show up, and like, it doesn't look suspicious, you know, like, we had nothing to do with the fire. They're not going to question us about it. It just looks like, you know, they're going to start an investigation. Maybe they'll, whatever, look for whatever. But like, if he's got a minute, and think about what he just did. Like, he's got no choice, man. He's using that passport and he's getting the hell out of here. But he never had the opportunity. Because he never left the Ocean County Police Department. Because we found certain things quickly enough to make it clear that he had something to do with this fire. Now, he wasn't charged with murder right away. Detective Zerillo told you that. It's like 8 days later or something. So it's not like they just said, you killed everybody and they charged him. No. But based upon the evidence they uncovered pretty quickly in Ocean, the cameras and all that kind of stuff, and shutting off the cameras, he gets charged with the arson of his own house. I digress a lot, so some of these slides I've probably said ad nauseum to you already. But this is about evidence, and it's not about one little piece of evidence. It's about the combination of a ton of evidence that is all pointing squarely Paul Caneiro. Talked about that. But I kind of want to close this because, you know, it was brought up in opening statements that there was another brother. Sounded to me, my recollection is that basically they were saying that Corey Caneiro did this, right? Now, I just wanted to put in context, like, that you have not heard anything about anyone entering that house other than him or other than his family in Colts Neck. In Ocean. Like, you have not seen other people on camera. You have not seen other evidence. So let's just think about if he's framed. Okay? Because again, if what they argued in openings and yesterday in summations is in any way true, he has to be the unluckiest man in the world, because we would have seen this had he not shut off his own cameras. So it's like, kind of shut up his own house. So, between 1:31 and 2:08, because remember though, Paul Caneiro told the police he was asleep, right? He told them that he hadn't been in the basement since 4 p.m. the day before. We know that's for sure. But between 1:31, that's when he shuts off the cameras in the basement, on camera, and 2:08 when the car leaves. Corey or whoever has to sneak inside 27 Tilton. Now, Caitlin Caneiro told you when she testified, Ms. Wallace asked her, you know, she was the last one to go upstairs that night. I think she said it was about 11:30. Ms. Wallace asked her, were the doors locked? Like the rear doors that you heard a lot about. You heard that they were open, right? Lieutenant Catalona told you about that? How he also told you about how he checked all the doors for visible fingerprints and things like that, and he didn't find any. But those doors, when she went to bed, are unlocked. How is someone getting in this locked house? How is Corey Caneiro getting in it? You didn't hear, like, you heard a lot, like, oh, Corey came over one time or several times with the kids and used the pool when we weren't home. Like, who was that? That's like, hey, Corey's been alone in the home before. He could have done something. But did he? No. you hear any of that evidence? No. Is it evidence? No. Okay? They're trying to kind of give that, like, oh, Corey was there alone once, like, maybe he did it. Okay, so between 1:31 when we know he's awake, okay, last time, like, you see him awake because it's the last time a camera's on. Between that time and 2:08, Paul's got to go to bed, fall asleep, and someone's got to figure out how the hell to get into that house. Several of the doors have chimes, right? You know, you heard about the soundproofing. I've never heard that before, but you heard it. I guess there were some soundproof rooms. That's convenient now, but it is what it is. Corey or whoever's now also got to get in the house. He's got to go down to the basement. He's got to figure out where to, I guess, find a key or a combination to the lock for the safe with the guns. Because he's got to get the guns, right? Got to get the gun, got to get the Fiocchi ammunition. He's got to find the key to the Macan, right? I mean, I think it's safe to assume when you have a loaner car, and I think he only had it for a couple days. I knew it was a short period of time, but one of his daughters said that. Anybody get a loaner car when their car's getting serviced and get more than one key? If they're not buying the car. You're not buying the car. They're giving you one key. This is the Audi key, but it's one key. Okay, so he's got to find the key. He then has to go back outside quietly, get in the car, drive to Colts Neck, do everything he did in Colts Neck, take the panel off, disable the generator, no testimony that anyone other than, not even Ben kind of said it, who was like aware of everything, but like the only person you ever heard about any knowledge about the generator and all that electricity and stuff in the basement is Paul Caneiro. But whoever goes to Colts Neck, they got to rip the panel off, disable the generator, they got to shoot Keith with, like, I mean, there's no other way to explain it. You saw the photos. I got one right here when we talk about Keith. Like, he's got one shot in the back, comes out the stomach, through his hand. Every other gunshot is here up. I mean, that's a guy, that's a shooter who goes to gun ranges. That's a shooter who's got multiple guns. That's a shooter who practices. That's a guy who's got, you know, things in the backpack. One of the, is this one. The Mantis training system in the backpack in the Cayenne with the barrel and the silencer. Those are accurate shots. They're like crazy accurate shots. And that's like a guy who's got targets hanging in his basement next to the rest of his guns in his gun locker. That is like marksmanship. You don't need a laser. A laser target's only for practice, not the real thing. He's got to cut the ONT line in the basement. He's got to go back to Tilden. He's got to park the Macan. He's got to, again, get back in the house quietly when Marissa, Caitlin, Susan, and I guess Paul are all asleep in the house. That person then has to go back down to the basement, take the clothes off, stick them in the area where we would have seen them stick it, had the camera not been shut off. They had to go over by the gun safe. I guess now they must have the key or the combination at this point because they got it out the first time. But now they got to get the gun back in there. They got to take the barrel out. They got to know how to take the barrel out. Sergeant Clayton told you it's not complicated. I mean, I don't have a gun, so I don't. I've heard how you do it. It's pop the slide off, put the barrel in, take the barrel out, whatever. But they got to do that, and they got to have a reason to do that, which is very inconsistent with what we're talking about, setting someone up. And again, they'd be doing all this by that locker in that gun area with the cleaners and all that stuff. They'd be doing it in a place where they should have been on camera, but they weren't. Because of him. So he's either guilty of murder or he's the unluckiest man in the world. Person then has to get back out of the house, set the fire at 4:30. And then interestingly, I said it yesterday, but I don't know how the guys, the mystery guys that are at the house at 4:30, if that time's accurate, are still there at 5:02 or 5:01 and change when that second blaze starts in the garage area by the driveway. Like 32 minutes these guys are going to sit around? That's about as dumb as knocking on the door after you set fire to a house. It doesn't make any sense. It's just a way to try to figure out a way to say that despite the evidence all pointing to me and all being extremely devastating, hey, I got set up. But all these steps set fire to the house, put Paul's backpack not into the Macan, but into the Cayenne in the garage. And again, third place, we should have seen that backpack go into the Cayenne because it's in the garage and you saw it when he shut off the cameras. Unluckiest man in the world. And then Corey's got to go back before Caitlin calls and his wife gives him the phone and they speak before he comes over and takes him out for bagels. All these things would have had to happen. And he's only been asleep for what? I mean, he's in the basement at 131. Like, how quickly could Paul Caneiro have gone upstairs and gone to bed? Like what? I mean, minimum, he's got to go upstairs. He's got to lie down. No matter how tired it is, it takes a couple minutes. Like, within 20 minutes of that, all of a sudden, someone's sneaking into the basement and taking the gun and then leaving and then coming back and somehow getting in without serving anyone, without the dogs barking. The doors are locked, etc. And again, I didn't show this yesterday. I skipped past it by accident, but like in the context of where Mr. Caneiro is at 131, and he's not sleeping. Within a few minutes of this, someone else has got to sneak down here, right, and get that gun right out of here, A locked. You saw that big lock. There's pictures. You'll have it. Take a look. I forget what the way Catalan described it, but it's like there's some like twisting part of it. It's like it's a strong lock. Yeah, you use bolt cutters to cut it off. But we would have seen it. If someone else did it, we would have seen it. But we didn't because it was him, and that's why I shut the camera. Why would you swap the barrel? Why would you plant the blood on the evidence in the defendant's basement and then try to destroy it if you wanted to set someone up? It just doesn't make any sense. It's like, I hate this analogy. A lot of prosecutors use this analogy. It's like another thing I said I never do, but it's like the kid caught with their hand in the cookie jar, right? You know, mom walks in and catches the kid in the kitchen, he's got his hand in the cookie jar, he's got some crumbs on him, and all of a sudden his mom's like, "What are you doing, Paul?" And he goes, "It was Corey." That's really what we're talking about here. Follow the evidence. Follow the evidence. You know, it's implausible to understand how someone gets Mr. Caneiro's DNA on the inside of his jeans and in other places that we've talked about. Now, we're getting there. Obviously, you probably all recall video that was ultimately obtained from the Wise cameras at Keith's house. Same grouping of cameras where we saw the conversation in the office and in the kitchen. This is the Garage North camera, and obviously this is we've had about 16 minutes of video, 235 to 251, and you know, you see someone appear, right, and then you hear that metallic noises as the person's ripping the panel out or trying to, and it's taking time. You see the person go that way. But we're going to watch. We're going to watch a portion. See the glove there? Black glove. going back towards the generator. You just saw a small portion. There's about 15 minutes. You know, at times the light comes on, light comes off. He goes through. He goes over by the generator. That's where he's kind of over by the generator, over here. But he's not really gone very long because we know it's just a switch. Because if you know where it is, you just shut the auto on-off switch off, right? There's a lot of talk about measuring this. Like, yeah, you could measure this, right? You could see where that third panel is and how tall it is, right? But the problem with that is that there's no way to really tell because this camera's at an angle. Like, we're not shooting straight, right? So there's no way to tell or estimate the size of that person. I would submit to you. I would submit to you that what we're going to look at here, you slow it down, you can pause it, you can do whatever you want. But this person, regardless, and I know it's paused here, but if you watch it, feel free to watch it again. This person's got hair, right? Hair. And they're wearing black nitrile gloves. And that's entirely consistent with all the evidence. Now, obviously, nobody is identifying that person, right? It's impossible. But when you look at all the other evidence, in his car that's driving on Willowbrook just a little bit earlier, and then parking, out here, right? Out here past the solar panels, either on that driveway or in that little opening on the grass. Walks right up to this area, right? And remember, when we look out here, this is just a little patio here, and this is exactly where we find the shell casings. So he shuts off the generator, shuts off the electric. He actually doesn't even shut off the solar panels, which shows you that you kind of have to know the house, right? Because what you found out about the solar panel array is that it's not a backup source of power. And I don't know, I'm no electrician, but I would have thought that the solar panel might have done something when the power goes out, but it actually doesn't. And really the only people that know that are the people that were there when it was installed and the house was being built. Paul Caneiro, Keith Caneiro. So you wonder why that wasn't shut off, because it didn't need to be. But when you think about the evidence in this case, and I know hair is it's a little fact, it's just a little thing, right? But that's not Corey Caneiro. That's not Keith Caneiro in the middle of the night either, because they're both bald. And these gloves right here, Paul Caneiro's DNA on them. Just showed them to you. So it's we can't tell you everything. I wish maybe we saw something out here at around 3:42 with someone leaving the house, right? But we can't because he shut the power off. He shut the power off. Shut it off in Ocean, and he shut it off in Colts Neck. And when you do that, it makes you look really guilty. And I'd submit to you, it makes it look bad when you're trying to argue that we didn't do this or we didn't find this. Because we had no ability after 251 to see anything. We'll talk about that next. Shutting off the camera. Video from your rear neighbor. Other surveillance cameras untilted. Barrel in the bag with the silencer. DNA in your basement. Right by the point of origin. No, I'm surprised I haven't said this yet, but sloppy, right? Smart tech guy or smart tech guy who just killed his niece and nephew, and he's really just trying to figure out what the hell to do. Get rid of the evidence. Should have torched it directly, right? Nothing you can do about the gun because you can't hide the gun because it's registered, right? We talked about that yesterday. But you should have just torched it directly. Torched it. Put it outside. One would have thought, though, setting that fire outside that window, with the window open and pointing right into where this stuff's found, it should have been destroyed. Again, Ocean Township Fire Department really screwed Mr. Caneiro. That was the plan. It just didn't work. talk about the no shoes, like, his daughter said the other day that no one else had shoes on other than their mom. I didn't see that in the DVR, but, I mean, in the body-worn cameras. But regardless, I said it probably twice yesterday. It's got time to go back in the house. Comes out, fuck, I hit my hand or whatever it is. You know, even Caitlin Caneiro acknowledged that. Like, she didn't actually see her dad hit his hand. She heard him say it. I personally, sorry. I don't, he either was saying it to try to make his daughter think like he hit his hand because he's got that hand injury, and that hand injury comes from Colts Neck. Like, I'm sorry. There's no way that hand injury happened fleeing a fire, which, when they fled the fire, wasn't even that bad yet. I mean, there's some smoke, there's no flames. They're going down the stairs, they're leaving. Not saying it's not alarming, but like, that hand injury, there's no other way to look at it other than it's got to be from Sophia Caneiro. 17 sharp force injuries. And then Dr. Zhang told you about the blunt force injuries. He's got gloves on, right? But get the hell out of that hand somehow. But here, like we talk about, this is the mudroom, 27 Tilden. I won't belabor this, but this is the mudroom, and this is what you pass as you go into the garage to get the Cayenne to pull it out. I mean, here you just have like a pile of stuff, a pile of shoes. The next picture, there's other shoes. Like, I would suggest to you, in combination with all the evidence, is that like not wearing shoes that morning was just like a really trying way too hard to make it look like you were sleeping and you weren't in Colts Neck killing everybody. That's what that looks like to me. No coincidence. Again, when we talk about what cameras would have shown, this is the kitchen. This is the Wise camera on the counter at 15 Willowbrook, right next to Sophia's picture. Staring right out over here, exactly where Jesse is found lying on the floor. Jesse, next, lying on the floor. Lying on the floor. These are the kitchen cabinets, the jury box. It's lying right here. What's here? What's here? The mudroom, the garage, the door with the Nest cam. Freedom. Life. He was so freaking close to the outside. But power was cut. The Nest camera, I'll talk about it quickly. They kept showing me during cross-examination that picture of the Nest cam, right? Of what, they just kept showing it. And then all of a sudden, Lieutenant Petrozello testified. And then, he got asked about it. And it was like, oh, there's actually, an explanation, right? The Nest camera, so this is the door next to the garage. Okay, well, I think it's right here. It's the door next to the garage. So the garage is right over here. This is the front door, right? There's a bunch of video from Wise with people coming in the garage. That's kind of what they did. They pulled their cars in the garage. So, I'd submit to you that this door didn't really get used very much. But what this picture actually is the exact same picture, notifications at Nest to Caneiro in Ocean. Your cameras just got shut off. This is what it showed. This is a notification at 2:52 in the morning to Keith Caneiro saying your Nest camera is off. We know why it's off, because the panel just got ripped off and the generator's off. So the camera shuts off at 2:52 a.m. Lord only knows what this camera would have showed. But he cut the power. So I don't know what I don't understand what the point of this picture is. They argued to you that Petrozello should have followed up. He told you he got a communications data warrant, which is a search warrant for companies like electronic providers, service providers, like Nest. And he requested the records for November 19th, November 20th, because really that's what else is relevant. And when he got back from Nest, was that there was no footage. There were no activations. They're acting like this is an activation on the 20th. It's not an activation. This didn't come on because someone's at the door. It came on, or it gets emailed to them saying, this is what your camera looked like when it was cut. It's not an activation. It's a notification. Just like Paul Caneiro's. Like the one picture in Mr. Caneiro's basement, when he cuts the power, he's standing by the guns, in the storage locker. So he's in the picture. The other one, he's not actually in the picture when it gets unplugged. I don't know if they're both unplugged from the same place and he's only in one picture and not the other. But like, they're right next to each other, so he's there. But like, this is nothing. If there was video there was an activation at, let's say, 2:45, we would have got it from Nest. But there wasn't any, because no one was in this area. He's over on the other side of the garage, ripping the panel off. So this, ladies and gentlemen, is just confirming, all it is. It's confirming that the power was disconnected at 2:51, 2:52, just like that Wise camera showed you. Because kind of like the DVR in the garage, it's like, he's there, it's 2:51 and change, and all of a sudden, camera's off. Coincides with the noise and the jiggling and the ripping of the panel and the door on the ground, right? And the meter on the floor.
Can I see the attorneys for a second? Ladies and gentlemen, I'm going to give your mid-morning break at this point in time. Please don't discuss this case or do any research. And we'll be back out at about 10 minutes to 11. Thank you all. You turn the lights back on. Everybody in 15 minutes. back and we'll continue with the summations of the state.
I want to try to push towards the end of this and talk a little bit about the DNA, right? The DNA and what it actually means and what it doesn't mean. Now, I've said it many times, but his DNA, his genes, his house, Sophia and Jesse's DNA on it. Dr. Wright told you, relatives share DNA, we got it. Does that change, though, the cross-examination of Dr. Wright and how he indicated that many of these samples conclusively and reliably showed that the victim's DNA were on his clothes that he tried to destroy? That allele sharing argument, the question marks in the one column with Corey, it's just desperation and another attempt at betraying another member of his family. There's the knife, and this was recovered, as you'll recall. You can see the state of it now. Detective Vogt testified about how it was found in the foyer area, right? Kind of in an area that had been kind of, not necessarily dug out, but kind of collected in that area. And you'll recall that that's the area where Jennifer Caneiro was found. Remember those pictures? She had a little yellow blanket that they put on top of her, right at the top of the stairs that go down to the basement. And then her daughter is up the stairs on the landing. And that knife, obviously they didn't put the knife into that block in the kitchen, right? Because they didn't want to contaminate or transfer any evidence. But you could see, and you heard the testimony, that that knife came from Keith Caneiro's own kitchen. The knife that at least took part in the murder of Jennifer Caneiro, and took part in at least, because you don't necessarily know if that's the only knife that was used, right? That's the knife that was found. You don't know, potentially, if he left with another knife. I mean, you know from the testimony in this case, you brought out that black bag with Detective Catalona. We walked it up here, and we didn't really open it up and show you everything in it. Really no need. You saw some pictures in one of those drawers that was over by the metal gun locker in Mr. Paul Caneiro's house. By all the guns. There's a bunch of knives in there. But obviously, at some point, he has to turn to another weapon. They're arguing that because there's a gun and because there's a knife, there's two people. But, what evidence of there is that? You saw the garage camera, right? That's 15, 16 minutes of footage that shows one person. It's like he has a ton of bullets and all that kind of stuff, and he would have brought enough bullets. What if, for instance, he was just going to shoot everybody once? Or, he obviously could have shot Keith Caneiro once. I mean, one bullet, at the end of the day, would have killed Keith Caneiro. That one last shot on the jacket with the gunshot residue, and you heard from Judith Link from the state police, that cruciform tear, which is consistent with the gun firing against the fabric and causing that tearing, that was enough. So the fact that maybe he didn't quite bring enough ammunition, does that mean there's two people involved? I mean, presumably, he had a magazine. We don't know which magazine he used, because he had hundreds of magazines in his house. But we know how many bullets were found, right? We know how many bullets were found, and we'll talk about that when we get to the ballistics, but we're going to go to DNA. Now, again, importantly, because they did a lot to try to, I don't want to say denigrate, but they were trying to point out things about likelihood ratios and mixtures and things like that with the Bodie and with the star mix. You heard about star mix and how like 90 plus labs in the United States are using it now. State police got it in 2022. That's why we went to Bodie. And, you know, state police was actually kind of like behind the game, like because of COVID, and a lot of labs have it. And basically 80%, I think they said, of labs in the United States are using it. But like, put that aside for a second, because that's just a way, like Dr. Reich said, is that like, he see majority of what he sees as a DNA analyst is mixtures. So mixtures are common. So like when you see like, you know, they test something and there's two contributors and maybe there's just like a little bit of the second one, there's not enough there, it's a mixture. That's what star mix is able to do. And like comparing numbers, like, you know, Sophia is 8 sextillion or whatever, likelihood ratio. Like, that's great, right? I mean, that's very probative. That's her DNA. But like in that one sample, the defendant in that mixture might only be like 400,000. But that's also because, as you heard, there's something called like average peak heights and RFU and all that stuff, and I'm not going to get into the weeds. But like basically you have two contributors, and one of them just, there's not a lot of that DNA in that mixture, but it's there. And StarMix is able to actually opine on mixtures better than like real humans can. And that's why StarMix exists. But, you know, it was brought up that like StarMix doesn't give you a yes and no answer. Well, random match probabilities don't give you a yes or no answer anyway. DNA does not give you a yes or no. It basically says with an RMP that, you know, like in a hypothetical population of 1 million people, like I asked Dr. Wright, you would expect to find this profile one time. That's like how rare it is. So we look at sample 6-1-4-1, which is the right front shin of the genes. Right front shin is one of these samples over here. That was actually tested by the state police, and ultimately they generated one of those random match probabilities. One of the ones I think they intimated are more accurate. I would submit to you that they're all accurate. It's DNA. You know, it's just DNA is DNA. It doesn't lie. It doesn't tell you where it came from or who put it there, but it doesn't lie. It's just that sometimes, given the amount of DNA in a particular area, because remember, we're talking about one of these little white cuttings, we're talking about a small area, because you don't just like throw the genes in a conveyor belt and it comes out and says, you know, this is all Sophia, this is all Jesse. You have to sample different parts of it. When we talk about Jesse's DNA, they said ultimately that Jesse's DNA, or Jesse was the source of the DNA on the right front shin of these genes. And when you talk about how rare that is, right, that's really what they're trying to tell you when they give you that answer. They said that he was the source. And what they need to call something the source from their protocol, their, you know, their standard operating procedures and analytical thresholds and things like that, is that the RMP has to be greater than 1 in 7 trillion. So in a population of 7 trillion people, which is actually a lot bigger than the amount of people that have ever walked the face of the earth, you would expect to find that profile once. Jesse's DNA, Paul Caneiro's genes. Now, we talked about a scraping from the inside collar of a shirt, one of the shirts that's in that pile. DNA profile is approximately 100 million times more likely to occur if H1 is true, which is basically that Paul Caneiro is contributor 1 to that sample. So, like I said, we learned quickly that Sophia, that Jesse was a little later, but we learned quickly that several areas on those genes had Sophia Caneiro's DNA. So that's quickly. So like that's, again, like before we start digging into finances and all that kind of stuff, we see his car leave, come back, and then they find, well, the dog hits, the cadaver dog, hits on the scent of human remains, and lo and behold, the state police tells us that's Sophia Caneiro's place. Follow the evidence. Same way they told us early on that her DNA was on the handle, which tells you that that's the knife that was thrust into multiple areas of her body. So when we talked about some of the star mix evidence, some of the DNA that was tested by Bodie, we talk about sample. I think Dr. Reich in his PowerPoint, he had three samples he talked about. The first was E01A1, which is, I've said it many times, but it's the inside of the genes above the knee, right? It's kind of like wearing DNA. Like, you know, that's where you get things when you move, you walk, in the shed. Now, when he talked about it, he was like pointing out different things, and I'm not sure why he chose that sample, because it's very probative, A, and B, it's extremely conclusive. But what he didn't tell you is that contributor 1 was Sophia Caneiro with a likelihood ratio of 476 sextillion. That number doesn't just come out of the blue. That's science. And then contributor 2 was Paul Caneiro with a likelihood ratio of 3.7 quintillion. And when I asked Dr. Reich on cross-examination, are those reliable results? Sophia's results and the likelihood ratio, Paul Caneiro's results and the likelihood ratio. Is that reliable? And he said, yes. E01C1, another area on the genes. This is the exterior front right thigh. So up here, Sophia Caneiro, single source right here. He was saying, oh, you know, you could do a random match probability. I guess you could. But I think he said that the number would actually probably, interestingly he said that. He said if you did a random match probability on that number, 2.1 septillion, I think basically what he said is that it should be about the same, i.e. they're both pretty accurate. And that likelihood ratio is 2.1 septillion. Again, all numbers, when we put them in context, are bigger than the amount of people that are on the earth today, 8 billion we heard, and the number forever is about 100 billion. Again, Dr. Reich, this is reliable. I asked him specifically, is that a reliable result? Yes. E02B1, interior of glove 1. I know we saw the 6 gloves. Contributor 1, Sophia Caneiro. LR of 1 septillion. Dr. Reich, that's okay. That's reliable, right? Nothing wrong with that. E03A1, glove 2, exterior. Contributor 1, 59%. Likelihood ratio of 100 quadrillion. And we got to contributor 2, Paul Caneiro, 41%. LR of 45 quadrillion. That's actually like not, it's kind of like it's not an equal, it's not a 50-50 mixture, but like it's more Sophia, but there's a lot of Paul in there, right? And Dr. Reich, when asked by me, said, those conclusions are reliable. It's their expert saying that. E03B1, glove, interior, and they acknowledge, I think all the DNA people acknowledge that, like, we don't necessarily know which is the inside, which is the outside of those gloves. Like, it's just kind of impossible to tell. It's the way they came to it. However they got the glove, they treated the exterior as the exterior, interior as interior. But quite frankly, there's results on those gloves from interiors and exteriors that are very probative, so I would submit to you that, like, he gloved up. He gloved up. You saw it on the video. He gloved up because he didn't want to leave anything. Now the car is so clean. Sophia, 97% of that mixture, 986 tillion. Dr. Reich says there's nothing wrong with that result. Glove 4 exterior, Sophia Caneiro, 94%. LR of 726 sextillion. Nothing wrong with that result. Glove 5, Sophia Caneiro, you get the point. 870 sextillion. I mean, a bunch of this stuff went out together. Probably didn't need to test all these areas of all these gloves. But I mean, consistently, you're finding that Sophia Caneiro's blood is on these genes. E06B1 at the glove. And here we see contributor 1 this time, 58%, is Paul Caneiro with an LR of 49 billion. Sophia Caneiro, 42%, 19 quadrillion. No issue with either result from Dr. Reich, who was asked by, who was testifying on behalf. E10A, this is a swab from the lower kitchen cabinet. This is the one of the ones we talked about. This is the one where it's Jesse's blood at the bottom, and Sophia is down there clearly bleeding in the kitchen, but not where she was found dead. Not dead. But the two of them contribute to the blood on that lower cabinet. It's telling in that these are extremely probative DNA results. They're very reliable based upon the testimony that you heard from even their expert. But it's very probative, like, what the hell was happening in the dark in the kitchen. E11, this is a underneath the pull-out drawer near the sink, Sophia's DNA. And E12B, this was actually early DNA. This was like before we went to Bodie. And when we looked at that scarf, ultimately you saw the testimony that there was a bunch of defects in the scarf. And there was also, I think, 3 hairs. When you look at defects here, it's hard to tell a little bit, but there's some holes in here, which are consistent with knives. Like the blade of a knife, maybe holding the scarf around your hand, the gloves, because at some point this scarf is in Colts Neck, and at some point this scarf ends up with strands of hair, longer strands of hair from a late 8-year-old Sophia Caneiro. And when they tested this, the random match probability, meaning in a population of 14 octillion people, you would expect to find that DNA profile one time. E13 was, well, that was a scraping. Let me be clear, just so the record's clear. That was a scraping of the scarf. Once they took the hairs off, they scraped it to try to get a cross-section of, see if they get any DNA off it. And ultimately what they came up with on that was Sophia Caneiro. That was the 1 in 14 octillion. The hairs, we have E13, E14, they're 2 hairs, and the results in a population of 4.1 octillion or 34 septillion, you would expect to find that one time. We talked about 61-4-1, that's Jesse's DNA. Dr. Reich says that's reliable. This is what we look at. We're looking at the Bodie chart. And, you know, I think there was one sample that I asked them about Mr. Caneiro's DNA, and it was the one time he tried to kind of, I'm not sure if that's reliable, I'm not sure. And then I showed him a transcript, and we kind of resolved that he has said in the past that that is reliable. Their DNA expert concedes Sophia's DNA is on the jeans, it's on the scarf with defects, it's on the glove. All items from the defendant's basement. They're all reliable according to the defense DNA expert. He concedes Paul's DNA inside the jeans, we talked about it, and on 3 different nitrile gloves, black nitrile gloves, just like the one seen on the hand in the video at 2:35 to 2:51 outside 15 Willowbrook, next to the electrical panel. He says those LRs of 45 quadrillion, 200 million, and 49 billion are reliable results. You can see it's Jesse's DNA. So what we know is that Jesse, Sophia, and Paul all contributed to DNA on the jeans. Sophia's DNA is on the scarf, the hair. Sophia and Paul are on the gloves. This was played for you during the course of trial. It's Paul Caneiro having a conversation with the office manager, and it kind of relates to partially.
Please, I never needed her any more than I need her now.
I know, and it really, you know, the stability was not really the main thing. It was, you know, the fear.
Don't worry about it. They got what they wanted. I'm here.
So, in December of 2018, after he's charged, he's trying to get a former employee to come back and run the business. That's what he's worried about on December 5th, 2018, despite the fact that he's facing murder charges. His brother's dead, sister-in-law, Jesse and Sophia. But what Tiffany's saying on that phone call is that Larissa, the other employee, doesn't want to come back because she's scared. And what Mr. Caneiro says is, there's nothing to be scared of. I'm here. Doesn't say, because you heard some testimony that like Corey worked with the business to try to keep it running after the fact. Doesn't say. What he doesn't say is kind of telling, and it's kind of probative of really who did this. It's a little thing again, but he doesn't say like, be careful, Corey's showing up at the business. Like, that's what you got to worry about. He's saying, don't worry, there's nothing to be afraid of. Because they're worried that, like, someone's out there. Keith's dead. Paul had a fire. They don't know the whole story yet. Nobody does, because we're still working on it. Don't be afraid of Corey, who's at the business every day. They got what they wanted. I'm here. Back to, because that was December 5th, so we're in the midst of the investigation. Because like I said, this stuff doesn't appear, okay? This is effort. This is investigation. This is seizing items and sending them places to get tested to try to see. You don't know what you're going to find when you send ballistics to the ballistics lab. You don't know what the answer is going to be. You don't know what the DNA people are going to tell you. So you're in the midst of that. But then when you start to get those results, does it tell you anything other than Paul Caneiro did this? Again, this is just something I wanted to show because we talked about it earlier, but when you look at the rear and where the fire started, right in here, 1, 2, 3, 4. So that's just the context of what Dr. Gould's camera is showing you. Just so you can understand that, like, you did see the origin of the fire. You did see when it started. And you might have missed the very beginning of this, you know, the lighting. Obviously, I wish it was that light. Maybe you would have saw someone walk across. But it was dark out because it's 5 o'clock in the morning. This is the fire. This is the point of origin. The DNA is right inside there. And this line right here, if I had the picture, you'll have it, but John Lightbody, who did the origin and cause, he testified about a picture that's in this living room over here, right here. And you could see there was some like crown molding. It's kind of like up here. It's like some crown molding here. And there's like a, just like this, there's almost like a pillar when you transition from the family room to the dining room. And Lightbody said, yeah, right here you can see. This is where the fire was going. Right? And it kind of got knocked down. But, like, if this fire doesn't get knocked down, like, it's already in the basement. You can see down here, it's below ground. I mean, it's trying to hit that evidence, right? It's really trying to destroy that DNA. Just didn't. I mean, I don't know if the fire could have eventually destroyed the guns, too. I mean, maybe we would have gotten that evidence, but pretty easy. That fire keeps going to destroy genes. I mean, look at what it did to it. Look at what it caused. It caused that, and then it caused that over here, what we talked about yesterday, with the rest of the genes. We talked about this yesterday, but it's just like things that are brought up, and then all of a sudden, like, we give you some context, like Lieutenant Petrozello testifying about how, like, yeah, we did check that camera, like, you know, it was always like, you guys didn't check this, you guys didn't check that. Then all of a sudden, it's like he testified. He's like, no, it's not like a Willowbrook address or like a, whatever, drawing a blank on Dr. Volstein's street, like just to the left. But the house back behind Willowbrook, like up in the back, it's actually, the address is actually Route 34, because that's how close Route 34 is. And ultimately, talking about cameras, but the car that you see in Colts Neck before, on its way, leaving, like, we know what direction that's going, right? We know that's, I would suggest that based upon this and even the timeline they're trying to offer to you, that that's the Macan. So, like, I'm not sure why, even though they did check cameras on Route 34 and other places, however, you know, in the middle of the night, it's not always that easy on Route 18 to see what kind of car it is driving through a particular location. But I think the testimony stands on its own. But the point being is that he did look, right? That is a relevant camera. That camera, had it been closer to 15 Willowbrook, I mean, they're big properties, so it's kind of like a little different than, you know, Mr. Caneiro's property and the Oxford. Very nice houses, right? Nice pieces of property, but they're closer. So the cameras are going to be more probative. But here, I mean, it would have been great if we saw the car park. I mean, it would have been the McCann. But, like, he parked over there for a reason. He wasn't trying to be on camera. Like, he may go to Keith's house a lot, but he doesn't necessarily ever contemplate the idea that, like, Catherine Lucchese across the street has cameras. I mean, that's a big property, too. Pretty set back, and that's obviously why the footage is kind of had to be pieced together by virtue of, like, tail lights and different things. And timing, because it makes sense, and that's his car. We talked about the phone. I mean, just the reality, and I don't know, I said it yesterday, but I'll say it very briefly again, but the phone, I don't understand exactly how the phone does anything to tell you that all the evidence that points to Mr. Caneiro does anything other than point to Mr. Caneiro and prove that he's guilty. But, again, just the context of what Jennifer would have been doing. I mentioned before, like, we don't know if maybe she even went outside and got chased in. We don't really know because the cameras were cut, the power was cut. But whatever happened, ultimately, she was killed inside. She was shot. She was stabbed. Just like her son, her daughter, was stabbed. So I said this yesterday, but obviously there's some reason for concern. She's going to leave her bedroom. She's going to do it quickly. Whether Keith's gone trying to figure out the power. She hears the gunshots, whatever the case may be. She's not necessarily grabbing her phone and calling 911. I mean, obviously there's a lot of chaos going on. Clearly, didn't sound like there was a lot of time to react. Maybe she's just more worried about trying to protect Jesse, trying to protect Sophia. Maybe her instinct was just to help, and that her phone's upstairs, and that she's got a gun pointed at her, got a bullet that's about to be in her brain. Because this is what's going on. This is Jennifer's body. Remember when before the detectives, they wanted to protect the integrity of the scene and the investigation. And Detective Cordoma, Detective Vogt, and Lieutenant Mueller go in and take the body out. And Detective Flanagan, who took a lot of the photos, Detective Cordoma told you, he took a lot of the early photos. He was like the first guy there from forensics. And you could see the depths of the fire in the back of the house. Like, he got a real sense, which Cordoma said was very helpful. Seeing the the path and the evolution of the fire was very important to where it started. Because it wasn't always a certainty where it started. I think it started in that cedar closet. I didn't put the video in here, but one of the interesting things that you can see from Patrolman Mazzacola, his MVR, his camera and his police car. Remember, he pulls up to the front of the house. And there's a point in time his camera's just running, where he goes over to where Keith is. Dr. Bolstein's over there, and then another officer comes, and Mazzacola and Miyakawa, the two officers, they go around the side because that door is open. Remember kind of where that one live round is found on that southwest patio. There's an open door, and they find that door open, right? I think I said it yesterday. And obviously they looked at that area to see if there's any fingerprints or anything, but like that's kind of the way he went out. And that's probably just about the best way to get out when you're trying to get to your car. You're trying to do it quickly. But on that, once Mazzicola and Miyakawa, the other officer, they go around, you can actually see, well, first you see Dr. Goldstein open that door and smoke. And then they actually open the camera, the door where the camera would have shown them opening the door, but the power was cut at 2:52. But Mazzicola opens it and you see the smoke come out by the garage. But during the course of that body-worn camera footage, one of the guys, his name's Sergeant Savage, walks across the front while the other officers are over on the side. And like, when you look at the front of the house, all of a sudden, for the first time during during that body-worn, there's like a little area on the bottom of the house where you see the flame. And it's like to the left of the door. It's real low. It's the first time you see it in flames. All you saw was smoke in the front of the house. Flames were in the back. But that was like exactly where the fire had eventually pierced that cedar closet. Because it's coming up and out and it's just right there on the bottom. It just tells you visually that origin, was right. The area of origin being the cedar closet. That's exactly where it would have been. You saw the floor plans and the surveys. So it's just interesting to know. So again, we're just talking about what's going on. Why maybe she didn't take her phone. I'm not going to. You saw what you saw. This is just an X-ray, which just shows, obviously confirming gunshot wounds to the head of Jennifer Caneiro. That's all I can show you. That's all you need to see. Just talking about that blood. This is the foyer. What's going on in that house at 3:30 in the morning? Sophia running into the kitchen. Then we got Jesse, right, coming around to where he's ultimately going to take his last smoke-filled breaths. And we got, this is the one where it's Jesse and Sophia. Like, who would have thought? Just think about, Sophia's in the kitchen, and she's already bleeding. So she's already been attacked. But she's there, and there's only really one way to look at it. You can judge for yourself, for sure. Like, she's got to be, like, checking on her brother. But then she runs out of the kitchen, up the stairs, onto the landing. And that's where Carmelo Lamarca, the firefighter, ultimately found her. That's what Zane told you, that, like, she was left alive. Alive. 49% carboxyhemoglobin. Kind of a man. And then lastly, this is probably, we can't say conclusively, Cordoma kind of explained it as best you could, but like, see the swipes and all that, he told you about that, but like, this is now going east in the house towards where you exit the kitchen and you go up the stairs, and she would have passed her mom lying there on the ground. Her mom ultimately suffered fatal injuries so that she didn't inhale smoke. Jesse did. Sophia did to another level. This is the wound to Jesse's chin that we talked about. And there's just, I didn't show you the picture, but you'll have all the pictures, but and right in that area, the kitchen, the islands here, kitchen cabinets are here, right over here is like the windows. They find a projectile right here. Remember, they found the casing over by Jennifer, by the stairs. This is, I'm not going to show you anymore. This is just showing you the sharp force injuries through her shirt. I think she was wearing like shirt and like underwear, obviously sleepwear. I'm not going to show you any other photos. You saw what you needed to see. It's horrific. But the reality is, we all know it's horrific. Cause and manner of death is part of any murder case. Have an obligation to prove cause and manner of death beyond a reasonable doubt, like every other element. But at the end of the day, the question becomes, Who did? Right? Did. And at the end of the day, beyond a reasonable doubt, but beyond any doubt, the person responsible for inflicting those minutes, moments of terror in the dark upon children that trusted him, God only knows what they were saying to him, Paul Caneiro. Just the hair on the scarf. When we talk about the injury, like, the only evidence of injury at 27 Tilden, only evidence of injury upon that house or in that house, despite the testimony from Caitlin Caneiro, was really just that one area of blood, which was swabbed, and it was actually the firefighter. And I don't know if it was on the... He was being treated at the scene, but obviously it was confirmed that Sean Edson, the firefighter, hit his hand, or cut his hand, or whatever it was, on the doorway, or hit it up, or rubbed it on the doorway at some point to cause the blood, which was his. But let's talk about that injury, like this injury. Like, he told the police he injured his hand, so I mean, I don't think, to be honest with you, I'm not sure he really could have hid that from the police being there at the police station and outside for a lot of the day. I don't think he really could have hid it, so he told them that. But then in trial, all of a sudden, kind of like his daughter, who didn't tell the police this, I mean, Miss Wallace asked her that, says that she was actually like heard something. She didn't see it. She didn't see her dad hit his hand, but he was behind her as they're going down the stairs trying to get out of the house, and he said, "Fuck, my hand," or something to that effect. I would suggest that, like, not wearing shoes, shutting off the cameras and all that kind of stuff, that's just like, just trying to come up with an excuse for an injury that is entirely consistent with bludgeoning. 3 people inside a house. Aaron, about an hour earlier. I would suggest to you that when you look at all of the evidence, all the stuff we talked about, that injury happened in Colts Neck. Sophia's injury, I mean, you heard him, there's 17, I'm not going to run through them. There's really no reason. You saw a couple photos, that's really what you could see. But we're talking about all over the body. But I think when we talk about this, we have to put into context that DNA again with Jesse and Sophia. And the fact that, like, Jesse never left the kitchen. He's bleeding there. He never left there. He died there. Sophia's bleeding. She leaves there. And Dr. Zane told you about all those injuries that were consistent with defensive wounds. It was in a report, and he testified to it. He said injuries, like he listed like 6 or 7 of the 17 sharp force injuries that he believed, and you saw the leg and hands and shit, forearm and all that kind of stuff. But like, that little girl fought. I mean, nothing else I can say. That little girl fought. Again, I'm not going to show you photos because I'm not going to do that to you, But like, this is just like Dr. Zhang, like notes of just, what else can you say other than how much writing is on that chart, that diagram? I mean, you don't need to see blood. You don't need to see cuts. It's just, look at the writing. It doesn't even matter what it says. It's just a lot of writing. I won't say it again. You know that 49%, you know what Dr. Zhang said it meant. Michael Abraham, the guy from the ATF, the electrical engineer, he told you about the Verizon OT line. He told you about the generator. He told you about he was brought in because he's an expert. He's an electrician who worked for the ATF. And ultimately, he assisted with determining, what the power meant in conjunction with the fire, and ultimately what he determined was that there was no power. The home was de-energized at the time of the fire because he cut all the power and he cut all the cameras. This is the Verizon ONT line which was cut. I'm sure you remember that. This is a line that was purposely and knowingly cut so that no help would come. No smoke alarm would be triggered. No alerts to the outside world. This is what we have. This is the shell casing. This is the live round. No, sorry, this is shell casing. Shell casing. All Fiocchi, very rare ammunition. So rare, ladies and gentlemen. There's a lot of cross-examination about it. So rare that Sergeant Clayton said they have thousands of different types of ammunition at the state police. But they needed the prosecutor's office to bring them this. Because I hope you understood it. But just because it's the same ammunition here in Colts Neck and here in defendant's basement doesn't mean that that ammunition is going to mark the same in any gun. It's not going to be a match with any gun because it's the same ammunition. The point is, they want to use, Sergeant Clayton told you, they want to use like ammunition because it marks that. You want to use, he said, I think it said it's longer, right? But it's good to see the markings so that you can make very reliable and conclusive comparisons between items. But again, ammunition that's rare enough that the state police didn't even have it. This is what they do every day. But Paul Caneiro has it. It's exactly what's found in Colts Neck. This was brought up yesterday. You know, why would he use a knife if he had a gun? Now, I think I explained this morning, but you know, I don't know that I can ever answer it. One of the things the judge will tell you is that, like, we can't get into the head of someone. You're going to be asked, and you're going to be read the law about state of mind, and that when you talk about murder, you're talking about purposely and knowingly, or purposely or knowingly causing death or serious bodily injury resulting in death. But one of the things the judge will tell you, I suspect, is that we could never get inside someone's head, right? So we don't know exactly why someone always does it. But I would suggest that when we talk about there was the southwest corner, there's a live round right by where that door was open, right? Now, that live round was ultimately compared to other shell casings that Clayton tested, and we'll get there almost. And that round wasn't fired. It's a live round. So it kind of looks basically this. It is this. Same head stamp. But it was extracted from the same handgun as the other casings. So you match casings to the gun and bullets, fired bullets, to the barrel. But the extractor marks and the ejection marks were the same as all the other cartridges. So this round that was found right by where that door was found open in the back corner of the house, Mr. Caneiro probably went in and probably left. It's the same as all the other cartridge casing. And the reason why it's there, I asked Sergeant Clayton, is that really either there's a malfunction or he forgot that he racked the gun already and there's a bullet in the chamber. And so when he racks it again, it pops out. So it ejects, but it doesn't fire because he doesn't pull the trigger. So it's there. It's from the same gun. It's just another piece of ballistic evidence when you look at the numbers, because there's 6 shots outside. There's 2 shots that we know of in the house because we have a casing in one area, and then we have a bullet in the other in the kitchen. There's 1 round on the southwest, I think I said southeast, the southwest patio. And then we also later found, interestingly, we found out the state police actually told us, these jeans, when they were sent for testing, and that pile was sent for testing, ultimately, New Jersey State Police item 6-4 actually got like 6. I think it's the same number as the jeans, so they kind of like found that. Same headstand, Yoki ammunition in the pile. I think where they found it was the pocket of the jeans, but your recollection will control. But just another piece of ballistic evidence linking the guns to Paul Caneiro, the DNA to Paul Caneiro, ballistics and the DNA to Paul Caneiro. But again, we're talking about 10 shots. I mean, there could have been a 10-round magazine, could have ran out, could have been more than that. Could have missed Keith a couple of times. They were never found because they would have flown out to Willowbrook. I don't know. But at some point, during that interaction with Jesse and Jennifer and Sophia, we know a knife is used. Just because he had a gun and a knife doesn't mean that it's anyone other than Paul Caneiro. So, when we talk about the state police ballistics, we first talk about 5 bullets. We talk about these 5 bullets. State police numbers 11, 12, 17, 20, and 26. Its evidence numbers 302, 304, 309, 325, 331. So basically, ladies and gentlemen, what you heard from Chris Clayton, an expert in ballistics, is that any bullet that wasn't damaged enough or mutilated, like he testified, those ones that were found in the water, Jennifer's brain and Keith's brain, anything that was remotely intact, matched this barrel that was found in Keith's backpack, Paul's backpack. This is, just so we realize, this is actually the live round from the southwest corner. Okay, this is the one that, although it wasn't fired, it matches all the projectiles, all the shell casings. So these bullets fired from this barrel found in Mr. Caneiro's backpack. Now we have 7 shell casings from Willowbrook. Exhibit test 305, 306, 307, 308, 311, 312, 326. All these casings. Well, first, let's just say that he was able to determine first that these bullets were all fired from the same gun. You saw the pictures, right? It's basically pattern comparing, and we showed you the photos that show that the patterns match. Obviously, based upon his testimony, based upon his expertise, testifying, I think, 60-something times, been doing this for years at the state police, these bullets all matched each other. And then he drew a comparison of these projectiles, of these shell casings, and said they all match. Before he did the barrel and the gun. But ultimately, based upon test firing, comparison of test standards to the bullets, this barrel, Paul Caneiro's backpack, fired these bullets, caused the death of Keith Caneiro and Jennifer Caneiro. Remember, he swapped the barrel out, right? But ultimately, it is safe. We've said that a number of times at the gun line. So, obviously, this is something we treat with care. Okay? This is S-193. It's recovered from the defendant's basement in that locked gun storage locker. We treat it with care, we point it down and we make sure it's safe. Because at the end of the day, while it's lawful to possess this weapon legally, right? But this thing's a beast. You know, these have lawful uses, certainly. People use them for sport and to practice, and that's fine. But you talk about matching shell casings from a crime scene where 4 people are murdered to this. You got to treat this with care because this thing takes lives. And this, and this, and these, and these. So while we're here, that gun from his basement and that barrel from his backpack, separated carefully, meticulously, purposely, fired these bullets and expelled these shell casings. Somewhere between 326 and 330. And then he went into that house and he caused the rest of the carnage. This is, ladies and gentlemen, that is, and this is, and this is, and this is, and this is, and those jeans are, and they're shutting off the cameras, and all the footage we have of them leaving in the middle of the night, coming back in the middle of the night, 2 hours later. That is proof beyond a reasonable doubt. We ask you, as jurors, to hold us to proving this case beyond a reasonable doubt. And we say reasonable, right? Like, you know, they may point out that this wasn't done or this wasn't done, but like, you also have to hold us to a reasonable standard as to, like, what more can we give you? We gave you the gun, gave you the barrel, the projectiles, the bullets, the DNA. We showed you him shutting off his camera. I can't give you any more because he shut off the cameras. We followed the evidence in this case. Murder doesn't make sense, but murder happened. Murder happened November 20th, 2018, in the darkness. And it happened 4 times. There's no way I could justify anything remotely resembling a good reason. But it happened. Talked about timeline, I promise. Just about that. Just want to close the loop with respect to the timeline. Okay, you talked about it, and I think the defense, you know, Ms. Mastalone, I think it was with Lieutenant Petruzzello, we created a timeline and all that stuff, and I guess the idea was that, like, the timeline doesn't make sense, or there's not enough time to do this and not enough time to do that. Well, you'll have those timelines and evidence. They've been marked. I think Ms. Wallace then asked some follow-up questions, and we added some things. 3:50 is a phone call, first phone call. 6:05, Keith calls Paul the second time. 1:27 a.m., Paul plugs in his iPhone. Probably just after practicing with the laser light and that other 6 hours. 1:28, goes into the garage, shuts off his camera. We see the Cayenne, see what we would have seen. 1:31, he goes downstairs. Sorry. We see him here, right, and we see the gun locker. He's shutting off the cameras downstairs, making sure that you wouldn't be able to see him leaving the DNA and putting the gun back, swapping the barrel, et cetera, et cetera. And we get to the Porsche, clearly the Porsche Macan 207, leaving Tilden. 2:27, Porsche Macan, Willowbrook. 235, 251, the video we saw with the gloves and the hair. 252, the first alert from the Verizon, saying basically the Verizon box is not cut yet, but saying that power's cut to the area. Same way that camera, the Nest camera outside, said 252, right? Keith sends these text messages, 314 through 318, there's 4, but the last one says, really, it's not really a communication, it's a text message, but essentially if you want to look at that as communication, that right here is the last thing that Keith Caneiro would ever say. And it's basically telling his brother he's going outside to check on the generator. Little did he know that when he got outside to check the generator, these and this were going to end his life. We know the Verizon line cuts at 3:42 per what they said. So there was also some testimony. I'm not going to belabor it. It's 6 minutes. There's no question it's enough time. But it could have actually been a little bit before 3:42. I think Mike Abraham said that Verizon pings the box every once in a while. I think he said every 30 seconds. So, I mean, it could have been 30 seconds earlier. Who knows if that's even accurate, if it registers right away. But the line's cut. The fire's set. And then he runs, like, look at the pictures. I mean, I skip the nearest bathroom and I go to the next bathroom. That's probably the distance of me running to get to that car, to get onto Willowbrook at 3:48 and 17 seconds. And then, ultimately, 4:08, Porsche Macan returns to Tilton. Paul's iPhone is unplugged, 4:54. The main fire starts at 4:57. Porsche Cayenne pulls out 27 feet. I wanted to, I think I skipped it. If I could for 1 second. Apologize. Almost done. Just going to go to my one slide. I'm going to take you back for 1 second. Just camera 5. This is when the where the car pulls out. Then we have that garage fire. Can we shut off all the lights? So, we know the car pulls out. Mr. Caneiro pulls the Cayenne out. About 5 o'clock. Just fast forward, because we know we got about a minute and a half till that fire starts. We're going to let it run now. About 5:51. And just, when I talked earlier, this is that light by the garage. One of like the sconces or wall-mounted lights to the garage. Just in the next little while, just want you to pay a little attention to some movement, some shadows in this area before the flash. we said that the people that were alleged to have been there at 4:30 wouldn't have still been there at 5:02, so you can't really make both arguments. But what we see here is about a minute and 20 seconds, minute and 30 seconds after Mr. Caneiro pulls the Cayenne out. It's been suggested that like someone else had to be there to set that fire. Now I'd suggest to you that when you look at that, it's impossible to say that there wasn't someone there, i.e. Mr. Caneiro, who came out of the car and went back up there. It would have been as simple as we said. Like his family gets in the car, but like the wife went back inside. His daughter was calling 911, and I don't know exactly when she got in the car. They all got in the car. There's no doubt about that. But like, what if he just pulls the car out into the street? And whether the family's there yet or not, if they are, I forgot to shut the garage door. Boom, towards the freaking car. Because that's the car that you just used to kill everybody. Like, obviously, again, kind of a failed attempt at doing any damage to that car, but like, he either set that fire right before he pulled the car out and it just took a minute, or he went back up. I mean, that fire's not started. Because if you're talking about like someone else being there, Corey, whatever, man, if he's not there, he's sitting in the street. It's not like he's not there to see what happened. Like, that fire, ladies and gentlemen, is just another fire set by Mr. Caneiro. It's just another part of the entirety of this case. Okay? That video is obviously not clear enough to say conclusively, but I suggest that you see some movement in that area around that light and some shadows, and it just is not something that proves anything like someone else was there. No one told you that anyone was there. Paul Caneiro, ladies and gentlemen. Paul Caneiro. All of the evidence in this case, all of the ballistics, the DNA, the air ammunition, the hiding of the backpack, hiding of the barrel, they're all shutting off the cameras. They're all just ways to try to hide the evidence. The evidence that shows that he, and he alone, committed these crimes. You have video of him shutting off his cameras. You have video of him leaving at 2:07 and returning at 4:08. You have evidence to suggest that is certainly him outside of his brother's house. He had the barrel. The projectiles and the bullets from the scene matched the barrel that he separated from the gun and the gun. Sometimes, ladies and gentlemen, sometimes the evidence doesn't lie. Sometimes, no matter how hard you try to explain it away or give alternative theories to why his DNA or his niece's DNA is in the basement, and why someone would try to frame him but swap out the barrel. He's not the unluckiest man in the world, ladies and gentlemen. He's just guilty. He's just guilty. And that's simple. But one last thing I just really wanted to say, and the judge is going to read the law to you very shortly. He's the one who controls how you consider the facts of this case in relation to the law. And ultimately, he's going to give you, when you deliberate, you're going to get a verdict sheet. And this is just some questions that you're going to have to answer based upon all the time you spent here, all the attention you paid, the arguments of counsel, but most importantly, the evidence from the stand, the physical evidence. And you're going to have to answer some questions. They go a little something like this. I'm not going to read the whole thing yet, I promise. You're going to have to determine if the defendant is guilty of murder. Did he purposely or knowingly cause the death of Keith Caneiro, for instance, or serious bodily injury resulting in death? Okay? That's the determination we need to make with respect to each victim. Then you're going to get some other questions on some of them, kind of like, did he do it by his own hand, meaning, did he do it? Okay? And then there's some other questions like, did he do it for money, or with the children, you know, were they under the age of 14? You're going to answer some of these questions once you find him guilty of murder. And you're going to get some weapons charges. You're going to get the theft. You're going to get the misappropriation. The one thing is, with respect, so you understand, with respect to felony murder. Now, with felony murder, you just get Jesse and Sophia. And I just wanted you to understand that when we talk about felony murder, we talk about causing the death of the victim while in the course of committing a felony. Here, it's charged with the arson. And the reason why you have Sophia and Jesse and not Jennifer and Keith is because of that very fact that we know, based upon the testimony of Dr. Toma and Dr. Zhang, that, like, Sophia and Jesse were alive after the fire was set. So they were killed in the course of him setting fire to the house. Now, they're also victims of murder because they were purposely or knowingly killed by Mr. Caneiro. But I wanted you to understand that is really what we're talking about and why you just see them there as opposed to Keith, their father, and Jennifer, their mother. Ladies and gentlemen, I know that this is an emotional process. Just on behalf of Ms. Wallace, just want you to know that we appreciate the time that you've all devoted to this. I'm sure the defense does too. I'm not trying to grandstand here, but we do appreciate the time, the attention, how you showed up. Sorry if there were delays at times. Could have been our fault. Who knows? But when we talk about justice and we talk about things like reasonable doubt and presumption of innocence and things like that, just remember that, like, we get held to a very high standard, and that's the way it should be. Okay, we're the state. We have to prove. We have to convince you that this man committed murders, felony murder, weapons charge. We have to do it beyond a reasonable doubt. And that reasonable word is just kind of important because we have proven it to you beyond a reasonable doubt. The DNA, the ballistics, the cameras, all the other testimony, all the little things, like showing you he wasn't set up, showing you that that was just another way to try to deceive. I would argue to you that the evidence will not deceive you. It will take you to a place where you will go back into that room and you will decide amongst yourselves that this man, contrary to a lot of things you may have heard about him, this man, on November 20th, 2018, Colts Neck, New Jersey, killed his brother, sister-in-law, 11-year-old nephew, and his 8-year-old niece. Ladies and gentlemen, for one final time, we appreciate your time. The only just verdict in this case, the only one that follows the evidence, is that Mr. Caneiro is guilty of all these crimes. Thank you.
Okay, ladies and gentlemen, it's been a long morning. The next part of the process is going to be the charge. That takes a little bit of time to do because I have to explain it all to you. So what I think I'm going to do, because it's noon, I'm going to give you a longer lunch just to give you a little bit of time to kind of stretch out, clear your head. We'll come back right at 1:30 and we'll move right into the charge. And at that point in time, I'll give you a little bit more information, but we're not going to do anything until then. You guys are going to remember what I'm about to say. We all know, right? Ladies and gentlemen, you've now heard the summations. You have not heard my charge. You have not heard the law in this case. You cannot discuss this case. You got an hour and a half having lunch together. Don't do it. You cannot do it. You just have to have your lunch, relax, do whatever you need to do. Come back up. I will give you the law. You get to finally learn about this system of who's the alternates and how fun that is to figure that out. And then you'll start your deliberations in that room only. All right? So everybody have a good lunch. Mr. Decker, if you can move that. And I'll see everybody right at 1:30. Counsel, is there anything we need to put on the record before we?
No, Judge, I just, with respect to the PowerPoints, you want to mark copies of those as C exhibits or?
Not C's, but there'll be the next S exhibit or an S exhibit for you and a D exhibit for the defense. And while that won't go into the jury, it will be secured and be a part of the overall record in this case. Anybody have anything else for now? Yeah, sure. being offered for a very limited purpose. You may consider it insofar as it may relate to the defendant's ability to carry out these alleged crimes, i.e., that he had the means and or opportunity to commit the charged offenses. Or, if you do not find that this evidence to be relevant, you may then disregard it. You may not use this evidence for any other purpose, such as to conclude that the defendant has a bad character or that he has a propensity to commit violent crimes. You may not use this evidence to convict the defendant simply because he owned weapons or because you may personally disapprove of individuals who lawfully possess firearms. While the defendant lawfully possesses these firearms, training items, and related accessories in his home, the state alleges that the defendant unlawfully possessed a handgun outside of his home, specifically at 15 Willowbrook in Colts Neck, New Jersey. The state further alleges that the defendant possessed this handgun with the purpose to use it unlawfully against others. As you have heard, the state bears the burden of proving each element of the crimes charged beyond a reasonable doubt. You, as members of the jury, will decide whether the state has met that burden. You have heard testimony from, from prosecutors Decker and Wallace, Lieutenant Petrozzillo, and Captain Weisbrot speaking to a witness about the case at some point prior to coming to testify at trial. The law permits prosecutors and detectives to speak to a witness about a case before the witness testifies, and it permits assistant prosecutors and detectives to review with the witness the questions that may be asked at trial, including questions that may be asked on cross-examination. Speaking to a witness about their testimony is a normal part of preparing for trial. It is not improper as long as there is no suggestion made to the witness that the witness depart from the truth. You have also heard testimony that a witness read or reviewed certain materials pertaining to this case before the witness testified at trial. The law permits a witness to review certain materials if there is no suggestion made to the fact that the witness departed from the truth. The defendant contends that there is evidence before you indicating that some other person than him that may have committed the crime or crimes, and the evidence raises a reasonable doubt with respect to the defendant's guilt. In this regard, I charge you that a defendant in a criminal case has the right to rely on evidence produced at trial that has a rational tendency to raise a reasonable doubt with respect to his own guilt. I have previously charged you regarding the state's burden of proof, which never shifts to the defendant. The defendant does not have to produce evidence that proves the guilt of another, but may rely on evidence that creates a reasonable doubt. In other words, there is no requirement that this evidence proves or raises a strong probability that someone other than the defendant committed the crime. You must decide whether the state has proven the defendant's guilt beyond a reasonable doubt, not whether the other person or persons may have committed the crimes. As you know, Paul Caneiro elected not to testify at trial. It is his constitutional right to remain silent. You must not consider for any purpose or in any manner in arriving at your verdict the fact that Paul Caneiro did not testify. That fact should never enter into your deliberations or discussions at any time or in any manner. Paul Caneiro is entitled for the jury to consider all the evidence presented at trial. He is presumed innocent whether or not he chooses to testify. All right, ladies and gentlemen, we've been going at this for about 55 minutes. Can you stand up for me for a minute? I just want you to stretch out yourself a minute or two. We're about to go into part 3. Take your time. You don't have to sit down because of me whenever you're ready. Part deals with the criminal code, which will give you the elements of the charges for each one of the crimes in the indictment. I'm going to be providing you with a lot of information. Don't panic. Just listen listen to what I have to say. I promise you by the time that this is over, I will make sure that it is easy for you. Right now, I just want you to listen to what I'm telling you. Try to digest it as much as you can. But again, just wait until the end, and then we'll talk about it. Okay? Now I will instruct you on the third part of the instructions on the portions of the criminal code that you must apply to the facts you find in determining whether the state has proven it beyond a reasonable doubt that the defendant violated a specific criminal statute. The statute read together with the indictment identifies the elements which the state must prove beyond a reasonable doubt to establish the guilt of the defendant on each of the counts in the indictment. In addition, you will have the opportunity to consider other offenses besides those charged in the indictment. This is what we call a lesser offense, crime or offense of a lesser degree that is included within the charges brought in the indictment. I will give you instructions about how to consider this lesser offense shortly. There are multiple charges in the indictment. They are separate offenses by separate counts in the indictment. In your determination of whether the state has proven the defendant is guilty of the crimes charged in the indictment beyond a reasonable doubt, the defendant is entitled to have each count considered separately by the evidence which is relevant and material to that particular charge based on the law as I will give it to you. Now I'm going to talk to you about a lesser included offense. The law requires that the court instruct the jury with respect to a possible lesser included offense or offenses, even if they are not contained in the indictment. Here, there is a lesser included offense of arson relative to the aggravated arson charged against the defendant Paul Caneiro in count 8 of the indictment. Just because the court is instructing you concerning this offense does not mean that the court has an opinion one way or another about whether the defendant committed this or any other offenses. You should consider these offenses along with those for which the defendant is indicted. However, you are not to render a verdict on this offense or answer the question on the verdict sheet unless you find that the state has failed to meet its burden regarding the offense of aggravated arson in count 8 of the indictment. Now I'm going to talk to you about the substantive charges in this case. Counts 1 through 4 charges the defendant with the murder of 4 different victims. In count 1 of the indictment, the defendant is charged with the murder of Keith Caneiro. The state alleges that on November 20th, 2018, in the township of Colts Neck, county of Monmouth, the defendant committed the crime of murder by purposely or knowingly causing the death of Keith Caneiro, or by purposely or knowingly causing serious bodily injury that resulted in the death of Keith Caneiro. In count 2 of the indictment, the defendant is charged with the murder of Jennifer Caneiro. The state alleges that on November 20th, 2018, in the township of Colts Neck, county of Monmouth, the defendant committed the crime of murder by purposely or knowingly causing the death of Jennifer Caneiro, or by purposely or knowingly causing serious bodily injury that resulted in the death of Jennifer Caneiro. In count 3 of the indictment, the defendant is charged with the murder of Jesse Caneiro. The state alleges that on November 20th, 2018, in the township of Colts Neck, county of Monmouth, the defendant committed the crime of murder by purposely or knowingly causing the death of Jesse Caneiro, or by purposely or knowingly causing serious bodily injury that resulted in the death of Jesse Caneiro. In count 4, defendant is charged with the murder of Sophia Caneiro. The state alleges that on November 20th, 2018, in the township of Colts Neck, county of Monmouth, the defendant committed the crime of murder by purposely or knowingly causing the death of Sophia Caneiro, or by purposely or knowingly causing serious bodily injury that resulted in the death of Sophia Caneiro. The statute upon which these 4 charges are based provides that a person is guilty of murder if he, 1, caused the death or serious bodily injury that then resulted in the victim's death. 2, the defendant did so purposely or knowingly. For you to find the defendant guilty of murder, the state is required to prove each of the following elements beyond a reasonable doubt. Number 1, that the defendant caused per count 1, Keith Caneiro, per count 2, Jennifer Caneiro, per count 3, Jesse Caneiro, per count 4, Sophia Caneiro's death, or serious bodily injury that then resulted in per count 1, Keith Caneiro, per count 2, Jennifer Caneiro, per count 3, Jesse Caneiro, per count 4, Sophia Caneiro's death. And 2, that the defendant did so purposely or knowingly. The first element that the state must prove beyond a reasonable doubt is that the defendant acted purposely or knowingly. A person acts purposely when it is the person's conscious object to cause death or serious bodily injury resulting in death. A person acts knowingly when the person is aware that it is practically certain that his conduct will cause death or serious bodily injury resulting in death. The nature of the purpose or knowledge with which the defendant acted towards per count 1, Keith Caneiro, per count 2, Jennifer Caneiro, per count 3, Jesse Caneiro, and per count 4, Sophia Caneiro, is a question of fact for you, the jury, to decide. Purpose and knowledge are conditions of the mind, which cannot be seen and can only be determined by inferences from conduct, words, or acts. It is not necessary for the state to produce a witness or witnesses who could testify that the defendant stated, for example, that his purpose was to cause death or serious bodily injury resulting in death, or that he knew that his conduct would cause death or serious bodily injury resulting in death. It is within your power to find that the proof of purpose or knowledge has been furnished beyond a reasonable doubt by inferences which may arise from the nature of the acts and the surrounding circumstances. Such things as the place where the acts occurred, the weapon used, the location, the number and nature of the wounds inflicted, and all that was done or said by the defendant preceding, connected with, and immediately succeeding the events leading to the death of per count 1, Keith Caneiro, per count 2, Jennifer Caneiro, per count 3, Jesse Caneiro, and per count 4, Sophia Caneiro are among circumstances to be considered. Although the state must prove that the defendant acted either purposely or knowingly, the state is not required to prove a motive. If the state has proved the essential elements of the offenses beyond a reasonable doubt, the defendant must be found guilty of the offense regardless of the defendant's motive or lack of motive. If the state, however, has proved a motive, you may consider that insofar as it gives meaning to other circumstances. On the other hand, you may consider the absence of motive in weighing whether the defendant is guilty of the crime charged. A homicide or a killing with a deadly weapon, such as a firearm and or a knife, would permit you to draw an inference that the defendant's purpose was to take life or cause serious bodily injury resulting in death. A deadly weapon is any firearm or other weapon, device, instrument, material, or substance which in the manner it was used or is intended to be used is known to be capable of producing death or serious bodily injury. In your deliberations, you may consider the weapon used and the manner and circumstances of the killings. If you are satisfied beyond a reasonable doubt that the defendant shot and killed Keith Caneiro with a firearm, you may draw an inference from the weapon used, that is a firearm, and from the manner and circumstances of the killing as to the defendant's purpose or knowledge. If you are satisfied beyond a reasonable doubt that the defendant shot and or stabbed and killed Jennifer Caneiro with a firearm and or a knife, you may draw an inference from the weapon used that the firearm and or the knife and the manner and circumstances of the killing as to the defendant's purpose or knowledge. If you're satisfied beyond a reasonable doubt that the defendant shot and or stabbed and killed Jesse Caneiro with a firearm and or a knife, you may draw an inference from the weapon used that is the firearm and or knife, and from the manner and circumstances of the killing as to the defendant's purpose or knowledge. If you are satisfied beyond a reasonable doubt that the defendant stabbed and killed Sophia Caneiro with a knife, you may draw an inference from the weapon used, that is the knife, and from the manner and the circumstances of the killing as to the defendant's purpose or knowledge. The second element that the state must prove beyond a reasonable doubt is the defendant caused, per count 1, Keith Caneiro, per count 2, Jennifer Caneiro, per count 3, Jesse Caneiro, per count 4, Sophia Caneiro's death or serious bodily injury resulting in death. As I previously advised you, to convict the defendant of murder, the state must prove beyond a reasonable doubt that the defendant either purposely or knowingly caused the victim's death or serious bodily injury that resulted in death. In that regard, serious bodily injury means bodily injury that creates a substantial risk of death. A substantial risk of death exists where it's highly probable that the injury will result in death. In order for you to find the defendant guilty of purposeful serious bodily injury murder, the state must prove beyond a reasonable doubt that it is the defendant's conscious object to cause serious bodily injury that then resulted in the victim's death, and that the defendant knew that the injury created a substantial risk of death, and that it is highly probable that the death would result. In order for you to find the defendant guilty of knowing serious bodily injury murder, the state must prove beyond a reasonable doubt that the defendant was aware that it was practically certain that his conduct would cause serious bodily injury that then resulted in the victim's death, that the defendant knew that the injury created a substantial risk of death, and that it was highly probable that death would result. Whether the killing is committed purposely or knowingly, causing death or serious bodily injury resulting in death, must be within the design or contemplation of the defendant. All jurors do not need to agree unanimously concerning which form of murder is present, so long as all believe that it was one form of murder or another. However, for a defendant to be guilty of murder, all jurors must agree that the defendant either purposely or knowingly caused the death or serious bodily injury resulting in the death of per count 1, Keith Caneiro, per count 2, Jennifer Caneiro, per count 3, Jesse Caneiro, and per count 4, Sophia Caneiro. If, after consideration of all the evidence, you are convinced beyond a reasonable doubt that the defendant either purposely or knowingly caused per count 1, Keith Caneiro, per count 2, Jennifer Caneiro, per count 3, Jesse Caneiro, per count 4, Sophia Caneiro's death or serious bodily injury resulting in death, then your verdict must be guilty as to that specific count of murder. If, however, after all of the consideration of the evidence, you find that the state has failed to prove any element of the offenses beyond a reasonable doubt, then your verdict must be not guilty as to that specific count of murder. As to purposeful or knowing murder counts, the state alleges that the defendant acted by his own conduct in causing the death of per count 1, Keith Caneiro, per count 2, Jennifer Caneiro, per count 3, Jesse Caneiro, per count 4, Sophia Caneiro. If you unanimously find that the defendant either purposely or knowingly caused the death of or serious bodily injury resulting in the death of per count 1, Keith Caneiro, per count 2, Jennifer Caneiro, per count 3, Jesse Caneiro, per count 4, Sophia Caneiro, you must also decide whether the state has proven beyond a reasonable doubt that the defendant committed the homicidal act by his own conduct. A finding of own conduct does not require a specific finding that the defendant's actions standing alone caused the victim's death. The relevant inquiry is whether the defendant actively and directly participated in the homicidal act or acts. The critical elements are whether the defendant acted and the immediacy of his conduct to the victim's demise. In other words, the defendant must be the direct and immediate cause of death to satisfy the own conduct element. Now, I want to give you the verdict sheet for a minute. asking you to do is not to flip through it. Just we're going to start right from the top for a minute. If you find the defendant committed the crime of purposeful knowing murder, and you unanimously agree that the state has proven beyond a reasonable doubt that he acted by his own conduct, you must answer yes to the own conduct question on the verdict sheet. You'll then be asked questions as it relates to the count in the indictment. So if you're looking at that right now, you see as to count 1, we're talking about Keith Caneiro. You'll answer the question, guilty or not guilty, as it relates to the crime of murder. The sub-questions underneath, the first question you're going to answer is whether it's done by his own conduct. You're going to answer that yes or no. Remember, you only get to own conduct if you found him guilty of the murder of Keith Caneiro. The next question would be yes or no, whether it was by his own conduct. If the answer to that is yes, then we're going to go to the other questions that you see there, which would then be 1B. And this is where we are. Okay, so 1A is that it's by his own conduct, and now let's go to 1B. The question is, did the defendant, Paul Caneiro, commit the murder in expectation of the receipt of anything of pecuniary value? If you unanimously agree that the state has proven beyond a reasonable doubt that the defendant did commit the murder in expectation of the receipt of anything of pecuniary value, then you must answer yes on the expectation of the receipt of a pecuniary value question. If the defendant, if you find the defendant committed the crime of purposeful or knowing murder, but you find that the state did not prove beyond a reasonable doubt that he committed the murder in expectation of the receipt of anything of value, then you must answer no to the expectation of the receipt of pecuniary value question. You'll still go, no matter what you answer for 1B, if you're now into these subsections, you're going to answer each one of them. You're going to answer B, C, and D, no matter what, if you've answered that he's guilty to count 1 and that he did it by his own conduct. Does that make sense, everybody?
Yes.
Yeah. Okay, so let's go to C, no matter what you say on B. If you find that the defendant committed the crime of purposeful or knowing murder and that he committed the crime by his own conduct, and you unanimously agree that the state has proven beyond a reasonable doubt that he committed the murder for the purpose of escaping detection, apprehension, trial, punishment, or confinement for another offense committed by the defendant, then you must answer yes to the committed for the purpose of escaping question on the verdict sheet. If you find the defendant committed the crime of purposeful or knowing murder, but you find the state did not prove beyond a reasonable doubt that he committed the murder for the purpose of escaping detection, apprehension, trial, punishment, or confinement for another offense committed by the defendant, then you must answer no on that part of the verdict sheet. As to count 1D, if you find unanimously that the defendant acted by his own conduct, you will need to determine whether the defendant committed the murder of Keith Caneiro while the defendant was engaged in the commission of, or an attempt to commit, or flight after committing or attempting to commit murder. If you find that the defendant committed the crime of purposeful knowing murder while the defendant was engaged in the commission of, or attempt to commit, or flight after committing or attempting to commit murder, and you unanimously agree that the state has proven beyond a reasonable doubt that he committed the murder while engaged in the commission of, or an attempt to commit, or flight after committing or attempting to commit murder, then you must answer yes to while in the course of a murder question on the verdict sheet. If you find that the defendant committed the crime of knowing and purposeful murder, but you find the state did not prove beyond a reasonable doubt that he committed the murder while engaged in the commission of, or an attempt to commit, or flight after committing or attempting to commit murder, then you must answer no on the while in the course of murder question on the verdict sheet. So that analysis that we just talked about, you're going to do that same exact analysis for Jennifer. If you find her defendant guilty of the murder of Jennifer Caneiro, and it is by his own conduct, you're going to answer those subsection questions. When we get to Jesse and the Sophia, Jesse is count 3, you're going to answer another question. Let's go to that one for a second. So if we're looking at that, all of us should be on page, I think it's on page 5, but let me just confirm. Yeah, I see it. 4 deals with JC, which is Jesse Caneiro. So if you go to page 5, which is where E is located, that's still the other question that we're going to ask for this one. As to Jesse and Sophia Caneiro, you will have additional questions. If you find unanimously that the defendant acted by his own conduct, you will also need to determine whether per count 3 Jesse Caneiro, per count 4 Sophia Caneiro were less than 14 years old. If you find that per count 3 Jesse Caneiro, per count 4 Sophia Caneiro were less than 14 years old, and you unanimously agree that the state has proven beyond a reasonable doubt that the defendant committed the murder per count 3 Jesse, per count 4 Sophia, while they were less than 14 years old, then you would answer yes to the victim was less than 14 years old question on the verdict sheet. If you find the defendant committed the crime of purposeful or knowing murder, but you find that the state did not prove beyond a reasonable doubt that the defendant committed the murder while each one of them, Jesse and Sophia, were under the age of 14, then you would answer no. So if you find that the state didn't prove that they were under the age of 14, then you would be answering no to that question, and that's E for each one of count 3 and for count 4. Does everyone see that on the verdict sheet? Yes. Okay, great. Now we're going to take all your verdict sheets back for a minute. Please just pass them down. That'd be great. Okay, the next charge is, the next 2 charges are for felony murder. Defendant is charged in count 5 of the indictment with the felony murder of Jesse Caneiro. The indictment reads in pertinent part as follows. Paul Caneiro, on or about November 20th, 2018, in or about the township of Colts Neck, county of Monmouth, did commit the crime of felony murder by causing the death of Jesse Caneiro while engaged in the commission of or an attempt to commit or in the flight after committing or attempting to commit the crime of arson. The defendant is charged in count 6 of the indictment with the felony murder of Sophia Caneiro. The indictment reads in pertinent part as follows. Paul Caneiro, on or about November 20th, 2018, in or about the township of Colts Neck, county of Monmouth, did commit the crime of felony murder by causing the death of Sophia Caneiro while engaged in the commission of or an attempt to commit and or flight after committing or attempting to commit the crime of arson. The state contends that on November 20th, 2018, while the defendant was engaged in the commission of or attempt to commit or flight after committing or attempting to commit the crime of arson, he stabbed and killed Jesse Caneiro and or Sophia Caneiro. The section of the statute applicable to this case reads in pertinent part as follows. Criminal homicide constitutes murder when it is committed when the actor is engaged in the commission of or attempt to commit or flight after committing or attempting to commit arson, and in the course of such crime or the immediately flight therefrom causes the death of a person other than one of the participants. Generally, it does not matter that the act which caused death was committed recklessly or unintentionally or accidentally. The perpetrator is as guilty of felony murder as he would be if he had purposely or knowingly committed the act which caused death. For you to find the defendant guilty of felony murder, the state is required to prove beyond a reasonable doubt from all the evidence in the case all the essential elements of the crimes charged. Accordingly, before you can find the defendant guilty of the felony murder of Jesse Caneiro in count 5 or Sophia Caneiro in count 6, the state must prove beyond a reasonable doubt that 1, on or about November 20th, 2018, the defendant was engaged in the commission of or attempt to commit or flight after committing or attempting to commit the crime of arson as noted as the lesser included offense of count 7, that the death of per count 5 Jesse Caneiro, per count 6 Sophia Caneiro was caused by the defendant, and number 3, that the death of per count 5 Jesse Caneiro, per count 6 Sophia Caneiro was caused at some time within the course of the commission of that crime, including its aftermath of flight and concealment efforts. The first element requires the state to prove beyond a reasonable doubt that the defendant was engaged in the commission of or attempt to commit or flight after committing or attempting to commit the crime of arson. In order for you to find the defendant guilty of arson, the state is required to prove each of the following elements beyond a reasonable doubt. That the defendant purposely started a fire at 15 Willowbrook Road in Colts Neck, New Jersey. 2, that the act of starting the fire recklessly placed per count 5 Jesse Caneiro, per count 6 Sophia Caneiro, in danger of death or bodily injury. You cannot find the defendant guilty of felony murder unless you first find him guilty beyond a reasonable doubt of having committed the crime of arson. And again, arson, as we're talking about here, is not what's charged in the indictment that I'm going to talk to you about in a minute, which is aggravated arson. This is the lesser offense of arson of what we're talking about. So for you to find him guilty of this charge, he has to be guilty of arson first. Everybody get that? Okay. All right. The second and third elements require the state to establish that per count 5 Jesse Caneiro, per count 6 Sophia Caneiro's death was caused by the defendant and was caused during the commission of or attempt to commit or flight after committing or attempting to commit crime of arson. To meet its burden of proof as to the second and third elements pursuant to count 5 and 6, the state must prove beyond a reasonable doubt the following. 1, that but for the defendant's conduct in the commission of or attempt to commit or flight after committing or attempting to commit arson, Jesse Caneiro and or Sophia Caneiro would not have died. In other words, that Jesse Caneiro and or Sophia Caneiro's death would not have occurred without the commission of the arson. Number 2, Jesse Caneiro and or Sophia Caneiro's death was a probable consequence of the commission of or attempt to commit or flight after committing or attempting to commit arson. For the death to be the probable consequence of the arson, the death must not have been too remote or too accidental in its occurrence or too independent on another's volitional acts to have a just bearing on the defendant's liability or the gravity of his offense. In other words, you must decide that if the state has proven beyond a reasonable doubt then under all of the circumstances, the death did not occur in such an unexpected or unusual manner that it would be unjust to find the defendant responsible for the death. In conclusion, if you find the state has proven beyond a reasonable doubt that 1, the defendant was engaged in the commission of or attempt to commit or flight after committing or attempt to commit the crime of arson, 2, that Jesse and or Sophia's death was caused by the defendant, and 3, that the death of the person was caused at some time within the course of the commission of the crime, including its aftermath or flight and concealment efforts, then you must find the defendant guilty of felony murder. On the other hand, if you find that the state has failed to prove beyond a reasonable doubt any one or more of those elements beyond a reasonable doubt, then you must find the defendant not guilty of felony murder. If you find that the state has failed to prove beyond a reasonable doubt that the defendant caused the death of Jesse Caneiro and or Sophia Caneiro, then the defendant should be found not guilty of all charged homicide offenses, including these 2 victims. If, however, you find beyond a reasonable doubt that the defendant did cause the death of Jesse Caneiro and/or Sophia Caneiro, but that the state has failed to prove beyond a reasonable doubt that the defendant was at the time engaged in the course of the commission of or attempt to commit or flight after committing or attempting to commit arson, then you still can consider the separate crime of murder. All right, counts 7 and 8. They both deal with aggravated arson. Count 7 of the indictment charged the defendant with aggravated arson in violation of 2C 17-1A. The indictment reads in pertinent part as follows. Paul Caneiro, on or about November 20th, 2018, in or about the township of Colts Neck, county of Monmouth, did commit the crime of aggravated arson by starting a fire, thereby purposely or knowingly placing Jesse Caneiro and/or Sophia Caneiro in danger of death or bodily injury, and/or with the purpose of destroying a building and/or structure of another, to wit, 15 Willowbrook Road, Colts Neck, New Jersey, belonging to Keith and/or Jennifer Caneiro. As to count 8, again, an aggravated arson charge. The indictment reads, Paul Caneiro, on or about November 20th, 2018, in or about the township of Ocean, county of Monmouth, did commit the crime of aggravated arson by starting a fire, thereby purposely or knowingly placing Susan Caneiro and/or Marissa Caneiro and/or Caitlin Caneiro in danger of death or bodily injury, to wit 27 Tilton Drive, Ocean, New Jersey, belonging to Paul Caneiro and/or Susan Caneiro. The section of the statute applicable to this case reads in pertinent part as follows. A person is guilty of aggravated arson if he starts a fire or causes an explosion, whether on his own property or another's. 1, thereby purposely or knowingly placing another person in danger of death or bodily injury, and/or 2, with the purpose of destroying a building or structure of another. For the defendant to be found guilty of aggravated arson, the state must prove the following elements beyond a reasonable doubt. 1, that the defendant purposely started a fire per count 7 at 15 Willowbrook Road in Colts Neck, per count 8 on his own property at 27 Tilton Drive in the township of Ocean. 2, that the act of starting the fire, A, purposely or knowingly placed, per count 7, Jesse or Sophia Caneiro, per count 8, Susan or Marissa or Caitlin Caneiro, in danger of death or or bodily injury, not serious bodily injury. And/or 3, was done with the purpose of destroying a building or structure of another, to wit, per count 7, 15 Willowbrook Road in Colts Neck, per count 8, on his own property of 27 Tilton Drive in the township of Ocean. So you're looking at 2 different ways the state can prove aggravated arson. It's either by way of causing danger of death or bodily injury to the individuals within the home, or for the purpose of destroying a building or structure of another, or in count 8 dealing with Paul Caneiro's own structure or house. Okay? The first element that the state must prove beyond a reasonable doubt is 1, that the defendant purposely started a fire at or near premises known as per count 7, 15 Willowbrook Road in Colts Neck, and count 8 his own property at 27 Tilton Drive in Ocean. A person acts purposely with respect to the nature of his conduct or a result thereof if it is his conscious object to engage in conduct of that nature or cause such a result. A person acts purposely with respect to attendant circumstances if he is aware of the existence of such circumstances or believes or hopes they exist. With purpose, design, with a design, or equivalent terms have the same meaning. Purpose is a condition of the mind that cannot be seen and can only be determined by inferences drawn from the defendant's conduct, words, or acts. It is not necessary for the state to prove the existence of such a mental state by direct evidence, such as a statement by the defendant that he had a particular purpose. It is within the power of the jury to find that the proof of purpose has been furnished beyond a reasonable doubt by inferences which you may draw from the nature of the acts and the circumstances surrounding the conduct of the defendant as they have been presented in the evidence you have heard and seen in this case. It is not necessary that any significant damage be done. It's only necessary that a fire be started for one or more of the purposes to be described. The lack of success of the perpetrator is immaterial. 2, the second element the state must prove beyond a reasonable doubt is that at the time the defendant started the fires, he purposely or knowingly placed, per count 7, Jesse and Sophia, per count 8, Susan, Marissa, or Caitlin in danger of death or bodily injury. Or his purpose was to destroy 15 Willowbrook in count 7 or 27 Tilton in count 8. Bodily injury means physical pain, illness, or other impairment of physical condition. I have already defined the term purposely for you. A person acts knowingly with respect to the nature of his conduct or the attendant circumstances if he is aware that his conduct is of such a nature or that of such circumstances. Let me start over. A person acts knowingly with respect to the nature of his conduct or the attendant circumstances if he is aware that his conduct is of that nature or that such circumstances exist, or he is aware of a high probability of their existence. A person acts knowingly with respect to a result of his conduct if he is aware that it is practically certain that his conduct will cause such a result. Knowledge is a condition of the mind that cannot be seen and can only be determined by inferences drawn by the defendant's conduct, words, or acts. It is not necessary for the state to prove the existence of such a mental state by direct evidence, such as a statement by the defendant that he had a particular knowledge. It is within the power of the jury to find the proof of knowledge that has been furnished beyond a reasonable doubt by inferences which you may draw from the nature of the acts and the circumstances surrounding the conduct of the defendant as they have been presented in the evidence you have heard and seen in this case. Destroy means to demolish and or render useless and or render completely ineffective for its intended use. If you find that the state has proven all the elements of aggravated arson beyond a reasonable doubt, then you must find him guilty of aggravated arson. On the other hand, if you find that the state has failed to prove all the elements of the aggravated arson beyond a reasonable doubt, then you must find the defendant not guilty. Now I'm going to talk to you about the lesser included offense of aggravated arson, which is arson. A lesser included offense to aggravated arson is in the indictment is arson. Can I see the attorneys for a second? Why don't you guys take a stretch for a second? You're more than halfway home. the ceiling if I jumped?
Probably.
Let's see.
Definitely here for your entertainment. I just want to.
At least the camera.
I'm going to say with absolute certainty, I can't do it.
Camera.
I think I can get the camera. And then, no my luck, I'll knock it off. Ladies and gentlemen, before when I was talking about the lesser included offense and you heard me stop for a second, one thing we're going to fix in the charge is that it's actually counts 7 and 8. So you will consider aggravated arson, obviously the indicted charges for 7 and 8. If you found him not guilty of aggravated arson, then you would consider arson for both counts 7 and 8, not just one of them. So I'm gonna fix that for you, but I also want to fix it for you verbally. Okay. All right. As I previously stated, the law requires that the court instruct the jury with respect to a possible lesser included offense, even if they are not contained in the indictment. Just because the court is instructing you concerning these offenses does not mean the court has an opinion one way or another. You should consider these offenses along with those for which the defendant is indicted. However, you are not to render a verdict on these offenses or answer the questions on the verdict sheet unless you find that the state has failed to meet one of the elements of aggravated arson in count 7 and or 8 beyond a reasonable doubt. Here's the elements of arson. A person is guilty of arson if he purposely causes a fire or purposely, it's getting good now. A person is guilty of arson if he purposely starts a fire or causes an explosion, whether on his own property or another's. 1, thereby recklessly placing another person in danger of death or bodily injury. In order for the defendant to be found guilty of arson, the state must prove beyond a reasonable doubt the following elements. Number 1, that the defendant purposely started the fire on either 15 Willowbrook Drive and or on his own property of 27 Tilton Drive in Ocean Township. And that 2, that the act of starting the fire recklessly placed at 15 Willowbrook, it would be Keith Caneiro and Jennifer Caneiro. At 27 Tilton, it would be Susan Caneiro, Marissa Caneiro, or Caitlin Caneiro in danger of death or bodily injury. The first element that the state must prove beyond a reasonable doubt is that the defendant purposely started a fire. It is not necessary that any significant damage be done. It's only necessary that a fire be started purposely. The lack of success of the perpetrator is immaterial. I've already defined purposely for you. For the state to prove this element of the offense, you must be satisfied beyond a reasonable doubt that it was the defendant's purpose or conscious object to start a fire. The second element the state must prove beyond a reasonable doubt is that the defendant, by purposely starting the fire, recklessly placed at 15 Willowbrook, it would be Keith Caneiro, it is, all right, I got to start over. I apologize. When we're talking about the arsons, as you recall, we were talking about, give me a second. A person is guilty of arson if he purposely starts a fire or causes an explosion, whether on his own property or another's. 1. Thereby recklessly placing another person in danger of death or bodily injury. In order to find the defendant to be guilty of arson, the state must prove the following elements beyond a reasonable doubt. That the defendant purposely started a fire at 15 Willowbrook Road, Colts Neck, New Jersey, and or 27 Tilton Drive in the Township of Ocean, New Jersey, and that the act of starting the fire recklessly placed at 15 Willowbrook Road, Jennifer Caneiro and or Keith Caneiro, and at 27 Tilton, Susan Caneiro or Marissa Caneiro or Caitlin Caneiro in danger of death or bodily injury. The first element that the state must prove beyond a reasonable doubt is that the defendant purposely started a fire. It is not necessary that any significant damage be done. It is only necessary that a fire be started on purpose. The lack of success of the perpetrator is immaterial. I have already defined purposely for you. For the state to prove this element of the offense, you must be satisfied beyond a reasonable doubt that it was the defendant's purpose or conscious object to start the fire. The second element the state must prove beyond a reasonable doubt is that the defendant, by purposely starting the fire, recklessly placed Keith Caneiro and or Jennifer Caneiro at 15 Willowbrook Road, or Susan Caneiro or Marissa Caneiro or Caitlin Caneiro at 27 Tilton in danger of death or bodily injury. Bodily injury means physical pain, illness, or any other impairment of physical condition. I've already defined the term purposely for you. A person acts recklessly when he consciously disregards a substantial and unjustifiable risk. The risk must be of such a nature and degree that, considering the nature and purpose of the actor's conduct and the circumstances known to him, its disregard involves a gross deviation from the standard of conduct that a reasonable person would observe in the actor's situation. If the state has failed to prove any of the elements as I've described to you beyond a reasonable doubt, you must find the defendant not guilty of arson. If you find the state has proven every element of the crimes charged beyond a reasonable doubt, then you would find him guilty of arson. So what's the difference between aggravated arson and arson? The act of purposely starting the fire is the same for aggravated arson and arson. The difference becomes in the second portion, whether he acted purposely or knowingly, putting these individuals, the victims, in the position of either in danger of either death or bodily injury. Purposely or knowingly for aggravated arson, recklessly for arson. So it's just the mental state that changes between aggravated arson and arson. Does that make sense? Okay. My confusion was just dealing with, I want to make sure that I was clear with the victims' names. Okay, we're going to count 9. Count 9 of the indictment charges the defendant Paul Caneiro with the crime of possession of a firearm with the purpose to use it unlawfully against the person of another. The indictment reads in pertinent part as follows. Paul Caneiro, on or about November 20th, 2018, in or about the township of Colts Neck, county of Monmouth, did commit the crime of possession of a firearm with the purpose to use it unlawfully against the person of another by possessing a handgun with the purpose to use it against Keith Caneiro and or Jennifer Caneiro and or Jesse Caneiro and or Sophia Caneiro. The statute on which this count of the indictment is based reads in pertinent part. Any person who has in his possession any firearm with a purpose to use it unlawfully against the person or property of another is guilty of a crime. For you to find the defendant guilty on this charge, the state has the burden of proving beyond a reasonable doubt each of the following 4 elements of this crime. 1. Exhibit S-193 is a firearm. 2. Defendant possessed the firearm. 3. Defendant possessed the firearm with the purpose to use it against another person or a person of another. 4. Defendant's purpose was to use the firearm unlawfully. The first element that the state must prove beyond a reasonable doubt is that S-193 is a firearm. A firearm means any handgun, rifle, shotgun, machine gun, automatic or semi-automatic rifle, or any gun, device, or instrument in the nature of a weapon from which may be fired or ejected any solid projectile ball, slug, pellet, missile, or bullet, or any gas, vapor, or other noxious thing by means of a cartridge or shell, or by the action of an explosive, or the igniting of flammable or explosive substances. It shall also include, without limitation, any firearm which is in the nature of an air gun, spring gun, or pistol, or other weapon of such a nature in which the propelling force is a spring, elastic band, carbon dioxide, compressed or other gas or vapor, air or compressed air, or is ignited by compressed air and ejecting a bullet or missile smaller than 3/8 of an inch in diameter with sufficient force to injure a person. The second element that the state must prove beyond a reasonable doubt is the defendant possessed the firearm. To possess an item under the law, one must have a knowing, intentional control of that item accompanied by a knowledge of its character. So a person who possesses an item such as a handgun must know or be aware that he possesses it, and he must know that it is that he possesses or controls, that it is a handgun. Possession cannot merely be a passing control, fleeting or uncertain in its nature. In other words, to possess an item, one must knowingly procure or receive an item or be aware of his control thereof for a sufficient period of time to have been able to relinquish his control if he chose to do so. The state must prove beyond a reasonable doubt that a possessor acted knowingly in possessing the item. A person acts knowingly with respect to the nature of his conduct or the attendant circumstances if he is aware that the conduct is of that nature, or that such circumstances exist, or he is aware of the high probability of their existence. A person acts knowingly as to the result of his conduct if he is aware that it is practically certain that the conduct will cause such a result. Knowing with knowledge or equivalent terms have the same meaning. As I told you in the past, knowledge is a condition of the mind. It can't be seen. It can be determined only from inferences, from conduct, words, or acts. Therefore, it's not necessary for the state to produce a witness to testify that a particular defendant stated, for example, that he acted with knowledge when he had control over a particular thing. It is within your power to find the proof of knowledge has been furnished beyond a reasonable doubt by inference, which may arise from the nature of the acts and the surrounding circumstances. A person may possess an item even though it was not physically on his person at the time of the arrest, if he had, in fact, at some point prior to his arrest, had control over it. Possession means a conscious, knowing possession, either actual or constructive. A person is in actual possession of an item when he first knows what it is. That is, he has knowledge of its character, and second, knowingly has it on his person at a given time. The third element that the state must prove beyond a reasonable doubt is that the defendant's purpose in possessing the firearm was to use it against the person of another. Purpose is a condition of the mind which cannot be seen and can only be determined by inferences from conduct, words, or acts. In determining the defendant's purpose in possessing the firearm, you may consider that a person acts purposely with respect to the nature of his conduct or a result of his conduct if it is in the person's conscious object to engage in conduct of that nature or to cause such a result. That is, a person acts purposely if he means to act in a certain way or to cause a certain result. A person acts purposely with respect to attendant circumstances if the person is aware of the existence of such circumstances or believes or hopes that they exist. The defendant's purpose or conscious objective to use the firearm against another person or the property of another may be found to exist at any time he has the possession of the object and need not have been the defendant's original intent in possessing the object. The fourth element that the state must prove beyond a reasonable doubt is that the defendant had a purpose to use the firearm in a manner that was prohibited by law. I've already defined purpose for you. This element requires that you find the state has proven beyond a reasonable doubt that the defendant possessed a firearm with a conscious objective, design or specific intent to use it against the person or property of another in an unlawful manner as charged in the indictment and not for some other purpose. In this case, the state contends that the defendant's unlawful purpose in possessing the firearm was to use it unlawfully against the person of Keith Caneiro or Jennifer Caneiro or Jesse Caneiro or Sophia Caneiro. So that's the only thing you're looking at for his unlawful purpose, what I've just described to you. You must not rely upon your own notions of the unlawfulness of some other undescribed purpose of the defendant. Rather, you must consider whether the state has proven the specific unlawful purpose charged. The unlawful purpose alleged by the state may be inferred from all that was said or done and from all the circumstances of this case. However, the state need not prove the defendant accomplished his unlawful purpose of using the firearm. If you find the state has failed to prove any of the elements of the crime beyond a reasonable doubt, your verdict must be not guilty. On the other hand, if you are satisfied that the state has proven each and every element of the crime charged beyond a reasonable doubt, your verdict must be guilty. The 11th count of the indictment charges the defendant with the crime of possession of a weapon for unlawful purpose to use it unlawfully against the person of another. The indictment reads in pertinent part as follows. Paul Caneiro, on November 20th, 2018, in or about the township of Colts Neck, county of Monmouth, did commit the crime of possession of a weapon for unlawful purpose by possessing a knife with the purpose to use it unlawfully against the person of Jennifer Caneiro and or Jesse Caneiro and or Sophia Caneiro. The statute on which this count of the indictment is based reads in pertinent part. A person who has in his possession any weapon with the purpose to use it unlawfully against the person or property of another is guilty of a crime. In order for you to find the defendant guilty of this charge, the state has the burden of proving beyond a reasonable doubt each of the following four elements. Number 1, Exhibit S313 is a weapon. 2, defendant possessed the weapon. 3, defendant possessed the weapon with the purpose to use it against the person or property of another. 4, defendant's purpose was to use the weapon unlawfully. The first element the state must prove beyond a reasonable doubt is that S313 is a weapon. A weapon is anything readily capable of lethal use or of inflicting serious bodily injury. Serious bodily injury means bodily injury which creates a substantial risk of death or which causes serious permanent disfigurement or protracted loss or impairment of the function of any bodily member or organ. It is possible that a knife is not normally considered a weapon. If, however, the state established beyond a reasonable doubt that the object is capable of being used to inflict serious bodily injury or death, it may be considered a weapon. The second element that the state must prove beyond a reasonable doubt is that the defendant knowingly possessed the knife. I've already defined possession for you. I've already defined knowingly for you. And I've already told you that knowledge is a condition of the mind, and it only can be determined based on inferences, conduct, words, or acts. A person may possess an item even though it was not physically on his person at the time of the arrest, if he had in fact at some time prior to his arrest had control over it. Possession means a conscious knowing possession, either actual or constructive. A person is in actual possession of an item when he first knows what it is, that is, he has knowledge of its character, and second, knowingly has it on his person at a given time. The third element that the state must prove beyond a reasonable doubt is that the defendant's purpose in possessing the object was to use it as a weapon against Jennifer Caneiro or Jesse Caneiro or Sophia Caneiro. As I've told you in the past, purpose is a condition of mind that cannot be determined, that can't be seen. It can only be determined by inference from words, conduct, or acts. In determining the defendant's purpose in possessing the weapon, you may consider that a person act purposely with respect to the nature of the conduct or a result of his conduct if it is the person's conscious object to engage in conduct of that nature or to cause such a result. That is, a person acts purposely if he means to act in a certain way or to cause a certain result. A person acts purposely with respect to attendant circumstances if the person is aware of the existence of such circumstances or believes or hopes that they exist. Defendant's purpose or conscious object to use the weapon against the person or property of another may be found to exist at any time he is in possession of the object and need not have been the defendant's original purpose in possessing the object. The fourth element the state must prove beyond a reasonable doubt is that the defendant had a purpose to use a weapon in a manner that is prohibited by law. I've defined purpose for you already. This element requires that you find that the state has proven beyond a reasonable doubt that the defendant possessed a weapon with a conscious objective, design, or specific intent to use it against the person or property of another in an unlawful manner as charged in the indictment and not for some other purpose. An object may be possessed for an innocent or for a lawful purpose. However, an innocent or lawful purpose or possession of a weapon may change and become unlawful and a violation of this statute. The state need not prove defendant's original purpose in possessing the weapon. The state need only prove beyond a reasonable doubt that the defendant's purpose at a specified time he possessed it was to use it unlawfully against the person or property of another. In this case, the state contends the defendant's unlawful purpose in possessing the knife was to commit serious bodily harm, resulting in the death of Jennifer Caneiro and or Jesse Caneiro and or Sophia Caneiro. You must not rely upon your own notions of the unlawfulness of some other undescribed purpose of defendant. Rather, you must consider whether the state has proven the specific unlawful purpose charged. The unlawful purpose alleged by the state may be inferred from all that was said or done and from all the surrounding circumstances of this case. However, the state need not prove the defendant accomplished his unlawful purpose of using the weapon. If you are satisfied beyond a reasonable doubt that the state has proven each of the elements that I've defined to you beyond a reasonable doubt, then you should find him guilty. However, if you find that the state has failed to prove any of those elements beyond a reasonable doubt, then you would find him not guilty. Count 12 of the indictment charges the defendant with unlawful possession of a weapon. The indictment reads, Paul Caneiro, on or about November 20th, 2018, in or about the Township of Colts Neck, County of Monmouth, did commit the crime of unlawful possession of a weapon by knowingly possess a knife under circumstances not manifestly appropriate for such lawful uses as it may have. That section of our statute provides in pertinent part, any person who knowingly has in his possession any other weapon under circumstances not manifestly appropriate for such lawful uses as it may have is guilty of a crime. To convict the defendant of this crime, the state must prove the following elements beyond a reasonable doubt. 1. S-313 is a weapon. Count 2, the defendant possessed a weapon knowingly. Count 3, defendant possessed a weapon under circumstances not manifestly appropriate for a lawful use. The first element that the state must prove beyond a reasonable doubt is that S-313 is a weapon. A weapon is anything readily capable of lethal use or of inflicting serious bodily injury. The second element the state must prove beyond a reasonable doubt is that the weapon was knowingly possessed by the defendant at a time and place alleged. Here the state alleges that the defendant possessed the weapon on or about November 20th, 2018 in Colts Neck, New Jersey. I've already defined knowingly for you. Knowledge is a condition of mind. It can't be seen. I've already explained how to analyze this mental state. Thus, the person must know or be aware that he possessed the item, here a knife, and then he must know what it is that he possesses or controls. In other words, that it is a knife. This possession cannot merely be a passing control that is fleeting or uncertain in its nature. In other words, to possess within the meaning of the law, the defendant must knowingly procure or receive the item possessed or be aware of his control thereof for a sufficient period of time to have been able to relinquish his control if he chooses to do so. When we speak of possession, we mean a conscious knowing possession. The law recognizes two kinds of possession, actual and constructive. A person is in actual possession of a particular article or thing when he knows what it is. That is, he has knowledge of its character and knowingly has it on his person at a given time. A person who, with knowledge of its character, knowingly has physical control over a thing at a given time is in actual possession of it. The law recognizes that possession may be sole or joint. If one person alone has actual or constructive possession of a thing, possession is sole. The third element that the state must prove beyond a reasonable doubt is that the defendant possessed S-313 and or another knife under circumstances not manifestly appropriate for such lawful uses as it may have. It is not necessary for the state to prove that the defendant formed an intent to use S-313 or any other knife as a weapon. It is, however, necessary for the state to prove that it was possessed under such circumstances that a reasonable person would recognize that it was likely to be used as a weapon. In other words, under circumstances where it posed a likely threat of harm to others. You may consider factors such as the surrounding circumstances, size, shape, and condition of the object, the nature of its concealment, the time, place, and actions of the defendant when it was found in his possession to determine whether the object was manifestly appropriate for its lawful use. If the state has proven each element beyond a reasonable doubt, each of the elements of this particular charge beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if the state has failed to prove any one of those three elements beyond a reasonable doubt, then you must find him not guilty. Count 13, theft. Count 13 of the indictment charges defendant with theft by unlawful taking or disposition of movable property. The indictment reads as follows. Paul Caneiro, bless you. Paul Caneiro, on or about diverse dates between January 1st, 2017 through November 19th through 2018, in or about various municipalities in the county of Monmouth, including but not limited to the Township of Ocean and or the Township of Colts Neck, county of Monmouth, did commit the crime of theft by unlawfully taking or exercising unlawful control over movable property of another, to wit, money valued at $75,000 or more belonging to Keith Caneiro or Jennifer Caneiro, Jessica Caneiro, and or Sophia Caneiro, with the purpose to deprive the owner thereof. The statute upon which the indictment is based provides in pertinent part that A person is guilty of theft if he unlawfully takes or exercises unlawful control over movable property of another with purpose to deprive him thereof. The state must prove each of the following elements beyond a reasonable doubt. 1, that the defendant knowingly took or unlawfully exercised control over movable property. 2, that the movable property was property of another. 3, that the defendant's purpose was to deprive the other person of the movable property. The first element which the state must prove beyond a reasonable doubt is that the defendant knowingly took or exercised unlawful control over movable property. Property means anything of value, including tangible and intangible personal property. Movable property means property with a location of which can be changed, including things growing on, affixed to, or found in land or documents, although the rights represented thereby have no physical location. For comparison purposes, immovable property is all other property. Defendant must knowingly take or exercise unlawful control over movable property. I've already defined knowingly for you. Knowledge is a condition of the mind. It can't be seen. I've already explained how to analyze that mental state. In this case, the state alleges that the movable property taken or over which control was unlawfully exercised is the following: money valued at $75,000 or more. It should be noted that the definition of movable property is broad, including the kind of property which has no real location. The state need not prove that the property was carried out of the place in which it was kept, but only that it was moved or taken from its original location, or that defendant exercised unlawful control over it, whether he was able to actually move or remove the property. The second element the state must prove beyond a reasonable doubt is that the movable property is property of another. Property of another includes property in which any person other than the defendant has an interest, which the defendant is not privileged to infringe, regardless of the fact that the defendant also has an interest in the property, and regardless of the fact that the other person might be precluded from civil recovery because the property was used in an unlawful transaction or is subject to forfeiture or as contraband. Property in the possession of the actor shall not be deemed property of another who has only a security interest therein, even if legal title is the creditor pursuant to a conditional sales contract or other security agreement. The term property of another is broadly defined to include services and intangibles, anything of value. Anything of value is defined as any direct or indirect gain or advantage to any person. The third element which the state must prove beyond a reasonable doubt is that the defendant's purpose was to deprive the other person of the movable property. For the purpose of this statute, the term deprive specifically means 1, to withhold or cause to be withheld property of another permanently, or for so extended a period as to provide a substantial portion of its economic value, or with purpose to restore only upon payment of reward or other compensation, or 2, to dispose or cause disposal of the property so as to make it unlikely that the owner will recover it. I've already defined purposely for you. It's a condition of the mind, can't be seen, and I've told you how to analyze it. If you find that the state has proven all of 3 elements beyond a reasonable doubt, then you must find the defendant guilty of that charge. If you find the state has failed to prove any of those elements beyond a reasonable doubt, then you must find him not guilty of that charge. Since the value of the property, the movable property, determines the degree or severity of the crime, the state must prove its value beyond a reasonable doubt. If you find defendant guilty, then you must indicate the value of the property. The state must prove the amount or value of the property beyond a reasonable doubt. So if you find the defendant guilty of the offense, then you must decide where it fits in the amount of money beyond a reasonable doubt. You kind of heard a little bit about that today. So you're going to answer the question, and I'll show you on the verdict sheet. If it's $75,000 or more, then you would check that one off. All 12 must agree. If you don't find that, but you find it's between $500,000 and $75,000, then and all 12 of you agree, then you would check off that number, and then we continue to go on. The third one is at least $200, but less than $500, and then the last one is just less than $200. And again, we're going to go over this on the verdict sheet. If you find that the amounts involved were taken in thefts committed pursuant to one scheme or course of conduct, the amounts may be added together to form a single total amount, whether stolen from one person or from several people. So again, you can add money together. If you find differing dates that money were taken, then you can add that money together in your overall determination of where it fits. Again, assuming that you actually found guilty of theft. If you don't find the three elements that would be guilty of theft, then we're not even talking about the amount of money that was involved. Okay. Count 14. Charges defendant with misapplication of entrusted property. The indictment reads as follows. Paul Caneiro, on or about diverse dates between January 1st, 2017 through November 19th, 2018, in or about various municipalities in the county of Monmouth, including but not limiting to the Township of Ocean and or the Township of Colts Neck, county of Monmouth, did commit the crime of misapplication of entrusted property by purposely or knowingly applying or disposing of property that was entrusted to them as a fiduciary, to wit, money valued at $78,180, belonging to Keith Caneiro and or Jennifer Caneiro and or Jesse Caneiro and or Sophia Caneiro upon agreement in a manner which they knew was unlawful or involved substantial risk of loss or detriment to the owner. The pertinent part of the statute on which the indictment is based reads as follows. A person commits a crime if he applies or disposes of property that has been entrusted to him as a fiduciary in a manner which he knows is unlawful and involves substantial risk of loss or detriment to the owner of the property or to a person for whose benefit the property was entrusted, whether or not the actor has derived a pecuniary benefit. The state must prove the following 6 elements of the crime beyond a reasonable doubt. 1. Defendant knowingly applied or disposed of property. 2. The property at issue was entrusted to defendant as a fiduciary. 3. Defendant's application or disposition of the property was unlawful. 4. Defendant's application or disposition involved substantial risk of loss or detriment to the owner of the property or to a person for whose benefit the property was entrusted. 5. Defendant knew that his conduct was unlawful. And 6. Defendant knew that his conduct involved a substantial risk of loss or detriment to the owner of the property or to the person for whose benefit the property was entrusted. The first element the state must prove beyond a reasonable doubt is that the defendant knowingly applied or disposed of property. Here the state asserts that the property was money, valued at $78,180. The term property means anything of value, even though it may be impossible to identify particular property as belonging to the victim at the time. Defendant allegedly misapplied the property because the victim's property may have been mixed with or joined with other property. Defendant must have applied or disposed of the property knowingly. I've already defined knowingly for you. I've also already told you that it's a condition of the mind and how you go about evaluating that element. The second element the state must prove beyond a reasonable doubt is that the property at issue was entrusted to defendant as a fiduciary. A fiduciary includes a trustee, guardian, executor, administrator, receiver, and any other person carrying a fiduciary function on behalf of a corporation or other organization which is itself a fiduciary. A fiduciary relationship arises between two persons when one person is under a duty to act for or give advice for the benefit of another on matters which within the scope of their relationship. The fiduciary's obligations to the dependent party include a duty of loyalty and a duty to exercise reasonable skill and care. The third element the state must prove beyond a reasonable doubt is that the defendant's application or disposition of the property was unlawful. That is, he applied or disposed of the property in a manner contrary to the responsibility as a fiduciary. In this case, the state asserts that the defendant's responsibility was to manage and administer the trust's assets in accordance with the terms of the trust agreement while acting in the best interest of the beneficiaries. As I have already explained, the state bears the burden of proving defendant's guilt beyond a reasonable doubt as to every element of the crime. The state's burden is not reduced or shifted to the defendant because he may have violated a fiduciary duty. The fiduciary duty of care is relevant to determine defendant's state of mind because it may have placed defendant on notice as to what was expected of him when he became the custodian of the property. A violation of a fiduciary duty in and of itself is insufficient as a matter of law to sustain a finding of criminal culpability. However, together with any other evidence in the case, you may consider defendant's breach of his fiduciary duty as evidence of the defendant's state of mind. The more egregious the violation, the more likely defendant acted knowingly. For example, an extended pattern of conduct displaying an utter disregard for his fiduciary duty would have more probative value than an isolated incident of bad record keeping or accounting. Fourth, the state must prove beyond a reasonable doubt that the defendant's application or disposition of the property involved substantial risk of loss or detriment to the owner of the property or to a person for whose benefit the property was entrusted. Fifth, the state must prove beyond a reasonable doubt that the defendant knew that his conduct was unlawful. I've already defined knowingly for you. Sixth, the state must prove beyond a reasonable doubt that the defendant knew that his application or disposition of the property involved a substantial risk of loss or detriment to the owner of the property or to the person for whose benefit the property was entrusted. A substantial risk is one that is of such a nature and degree that, considering the nature and purpose of defendant's conduct and the circumstances known to him, its disregard involves a gross deviation from the standard of conduct that a reasonable person would observe in the defendant's situation. In other words, the state must prove beyond a reasonable doubt that the defendant knew that it was very likely that his treatment of the property would create a risk of loss or detriment to the owner or person whose benefit the property was entrusted, and that defendant went ahead anyway, where a reasonable doubt would not. I've already defined knowingly for you. It is not necessary for the state to prove the defendant himself derived the benefit during his application or disposition of the property. If the state has proven each of the 6 elements of the crimes charged beyond a reasonable doubt, then you must find defendant guilty of misapplication of entrusted property. On the other hand, if the state has failed to prove any element beyond a reasonable doubt, then you must find him not guilty. If you find the defendant not guilty, your consideration of the misapplication of entrusted property charge should end here. However, if you found that he is guilty beyond a reasonable doubt, then you must proceed to make 2 additional factual findings. Specifically, you must indicate whether the defendant derived a benefit from his misapplication of entrusted property, and if so, the benefit he derived. First, you must determine whether the state has proven beyond a reasonable doubt that the defendant derived a benefit as a result of his misapplication of entrusted property. Benefit means a gain or advantage or anything regarded by the beneficiary as a gain or advantage, including but not limited to a pecuniary benefit or a benefit to any person or entity in in whose welfare he is interested. Please indicate whether the state has proven that the defendant derived a benefit from his alleged misapplication beyond a reasonable doubt by marking yes or no on your verdict sheet. And then, if you have determined both that the defendant is guilty of misapplication of entrusted property and indicated yes, that the defendant did derive a pecuniary benefit from the misapplication, then you must go on to determine the amount of that pecuniary benefit. Specifically, you should indicate on the verdict sheet if the benefit that the defendant derived has a value of $75,000 or more, or exceeds $500 but less than $75,000, or is at least $200 but doesn't exceed $500, or is less than $200. The benefit derived includes the value of all funds or property misapplied by the defendant. That is, the value of the property misapplied is not simply the value of its use during the period in which the defendant exercised control over the property. For example, if a defendant applies or disposes of $5,000, but later reimburses the victim, the value of the benefit derived is the full $5,000. It is not merely the amount of interest that a bank might have charged for the use of the $5,000 loan during the period in which the defendant made use of the money. Similarly, if a defendant applies or disposes of $5,000 but reimburses the victim for all but $200 of the amount, the benefit derived is still $5,000, the entire amount involved. In calculating the benefit derived, you must include, but are not limited to, the amount of any tax avoided, evaded, unpaid, improperly retained, or improperly disposed of. All right, count 15 and 16. These are the last two. The defendant is charged in count 15 of the indictment with the offense of hindering his own apprehension or prosecution, in that he is alleged to have, with the purpose to hinder his own detention, apprehension, investigation, prosecution, conviction, or punishment for the crime of murder, suppressed by way of concealment or destruction any evidence of the crime which may have aided in his discovery or apprehension in the lodging of a charge against him. The indictment reads as follows. Paul Caneiro, on or about November 20, 2018, in or about the township of Colts Neck or in the township of Ocean, County of Monmouth, did commit the crime of hindering oneself by, with purpose to hinder or his own detention, apprehension, investigation, prosecution, conviction, or punishment of the crime of murder, suppressed by way of concealment or destruction any evidence of the crime which might have aided in the discovery or apprehension or the lodging of a charge against him. As to count 16, defendant is charged in count 16 of the indictment with the offense of hindering his own apprehension or prosecution, in that he alleged to have, with the purpose to hinder his own detention, apprehension, investigation, prosecution, conviction, or punishment for the crime of theft and or misapplication of entrusted property, prevented or obstructed by means of force anyone from performing an act which may aid in his discovery or apprehension or in the lodging of a charge against him. The indictment reads as follows. Paul Caneiro, on or about November 20th, 2018, in or about the township of Colts Neck, County of Monmouth, did commit the crime of hindering oneself by, with purpose to hinder his own detention, apprehension, investigation, prosecution, conviction, or punishment for the crime of theft and or misapplication of entrusted property, prevented or obstructed by means of force anyone from performing an act which might have aided in his discovery or apprehension or in the lodging of a charge against him. These charges are based upon a statute which provides that a person commits an offense if, with the purpose to hinder his own detention, apprehension, investigation, prosecution, conviction, or punishment for an offense, he suppresses, by way of concealment or destruction, any evidence of the crime which might aid in the discovery or apprehension of such person or in the lodging of charges against him, or prevents or obstructs by means of force anyone from performing an act which may aid in his discovery or apprehension or in the lodging of a charge against him. For you to find the defendant guilty the state must prove each of the essential elements of the offenses beyond a reasonable doubt. Those elements are: 1, that the defendant knew that he could, might be charged with murder and or theft and or misapplication of entrusted property. 2, that the defendant suppressed by way of concealment or destruction any evidence of the crime which might have aided in the discovery or apprehension or in the lodging of a charge against him, and or prevented or obstructed by means of force anyone from performing an act which may aid in the discovery or apprehension or in the lodging of a charge against him. And 3, that the defendant acted with purpose to hinder his own detention, apprehension, investigation, prosecution, conviction, or punishment. The first element the state must prove beyond a reasonable doubt is that the defendant must have known that he could/might be charged or was liable to be charged with murder and or theft and or misapplication of entrusted property. I've already defined knowingly for you, and I've told you that it's a condition of the mind, and it has to be determined based upon inferences from the defendant's conduct, words, or act. The second element the state must prove beyond a reasonable doubt is that on November 20th, 2018, that the defendant suppressed by way of concealment or destruction any evidence of the crime and or prevented or obstructed by means of force anyone from performing an act which may aid in the discovery or apprehension or in the lodging of a charge against him. The third element that the state must prove beyond a reasonable doubt is that the defendant acted with the purpose of hindering the detention, apprehension, investigation, prosecution, conviction, or punishment for murder and or theft and or misapplication of entrusted property. I've defined purposely for you. If after considering all of the evidence you conclude that the state has proven each of these elements beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you find the state has failed to prove any of these elements beyond a reasonable doubt, then you must find him not guilty. We're very close. We're on to part 4. There is nothing different in the way a jury is to consider the proof in a criminal case from that in which all reasonable persons treat any questions depending upon, let me say that again. There is nothing different in the way a jury is to consider the proof in a criminal case from that in which all reasonable persons treat any questions depending upon evidence presented to them. You are expected to use your own good common sense. Consider the evidence for only those purposes for which it has been admitted, and give it a reasonable and fair construction in light of your own knowledge of how people behave. It is the quality of the evidence, not simply the number of witnesses, that control. As I've said before, an exhibit that has not been marked into evidence cannot be given to you in the jury room, even though it may have been marked for identification. Only those items marked into evidence can be given to you. Available to you in the jury room will be the discs of audio and or video evidence. Please note that these discs may only be played in the courtroom and not by you, the jurors, in the jury room. If you as jurors want to see or hear some part of those items of evidence, you have to send out a note and let me know. Even though there's a TV in there, you're not going to be able to use that. You're going to have to come out here. We're all going to be present, and we're going to watch it with you. Very shortly, you're going to go into the jury room to start deliberations. I remind you that during deliberations, and in fact, any time that you are in the jury room, you must keep any cell phone, pager, or other communication device that you possess off. You are to apply the law as I have instructed you, as I have instructed you, to the facts as you find them to be, for the purpose of arriving a fair and correct verdict. The verdict must represent the considered judgment of each juror and must be unanimous as to each charge. This means all of you must agree on guilt or innocent, or guilt or not guilty on a particular charge. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it was erroneous, but do not surrender your honest conviction as to the weight or effect of evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You are partisans. You are not partisans. You are judges of the facts. You may return to each crime charge a verdict of either not guilty or guilty. Your verdict, whatever it may be, must be unanimous, meaning all 12 deliberating jurors must agree. To assist you in reporting a verdict, you're going to have a verdict form. We can give them out right now. You had it before. We're going to give it now, and now you get to keep it. As we are giving that out right now, as brutal as that was for you to listen to me, was as brutal as it was for me to say it with my voice. But here's what I want to tell you. I just gave you the law verbally. Understanding how difficult that would be for all of you to remember all of that, each one of you will have your own binder that will have the charge as I just read it to you. So you're going to have that. Now you're going to say to yourself, are you kidding me? You just made me sit here and listen to that even though I could have just read it myself? That's not the way it works, ladies and gentlemen. I have to know, Mr. Caneiro has to know, all the attorneys have to know that you actually read every single page. That's why we read it together, all together in the same room, and it's on the record. And you should listen to my charge as I told it to you. It's not going to be different from this. I may have cut some things a little short because I had already told you once or twice, but you're going to have the actual charge as that I just verbally gave to you to be able to use as a reference, to be able to go back and listen for the elements when you're talking about a particular charge. Now, you have the verdict sheet in front of you. As you can see, and we talked about counts 1 through 4 already. I'm not going to go through this entire document, but I'm going to give you a flavor so that you understand. Okay? So when you look at that document right now, it does not give you the elements of all the crimes charged. All it gives you is basically an answer key for you to log in what your answers are for a particular charge. That's the only thing that we're using it for. It will also help you and guide you to make sure you answer any and all questions that are being asked of you. We've talked about questions 1 through 4, but you'll see with each question, underneath there will be a bold, for example, to tell you, do I have to go on to a subsection or do I go on to the next count? So, for example, as we talked about in count 1, how do you find, as to count 1 of the indictment charging the defendant Paul Caneiro with the murder of Keith Caneiro? It's either guilty or not guilty. And then you see underneath, if you find him guilty, then you're to answer 1A. If you find him not guilty, then you would just go to count 2. 1A deals with doing it by his own conduct, as we talked about before. If you answer yes to 1A, then you go to B and C. If you answer no to 1A, well, then you would not answer B and C, which is exactly the bolded parts underneath. And again, it goes to 1B and C. C is located on the next, D is located on the next page. And then you see, if you've gone through question 1A, B, C, and D, then you see underneath it says go to count 2. Same thing applies for each count. Let's go to, for a minute, let's go to count 7. 7 discusses aggravated arson. How do you find, as to count 7 of the indictment charging the defendant Paul Caneiro with aggravated arson, as to the structure of 15 Willowbrook Road? That is, if you answer that he's guilty of that charge, then you're not answering 7A. 7A only deals with arson. So it's the lesser included offense. If you found him not guilty of count 7, Then you would go down to 7A and answer that question because you found him not guilty of aggravated arson. So then you would consider the crime of arson. Does that make sense? Yes. And that's the same for 7 and 8. Let's go to count 13 for a minute, which is on page 14 of the verdict sheet. All right. How do you find as to the theft charge? If you find him guilty, then the 13A is the amount that you find, and that should be included at that particular point. Was it more than $75,000? If not, 500, but less than $75,000, you would check there. If not that, then the third category is exceeds 200 but less than 500. You would check there, and if then none of those apply, then the last one would be is less than $200. But remember, different from murder, when I said you can agree to one form of murder of either killing and or serious bodily injury resulting in murder, it doesn't matter as long as all 12 of you agree. When it comes to this, when you're talking about those ranges, all 12 of you have to agree to the same range. It can't be one different from the other. Okay? Count 14 deals with the misapplication of entrusted property. Again, if you find him not guilty of that charge, you would not answer A and B of 14. If you find him guilty of it, then you would go down to 14A. If you say yes to 14A, then you go to 14B, but if not, if you say no, then you would not go to 14B. Then the last two charges are just guilty or not guilty. So that is the verdict sheet. Now, if during your deliberations you have a question or you feel that you need further assistance or instructions from me or wish to have certain testimony read or played back, which is either audio or video or some type of exhibit that you needed to see that maybe you don't have, write your question or request on a sheet of paper and give it to the sheriff's officer who will be standing at the jury room door, who in turn will give it to me. The court officer will be sworn to perform certain duties, such as keeping the jury together in a private place for purposes of deliberations and ensuring that no one speaks with you except by order of the court. You are not to discuss with or ask the officer about any trial matters or procedures. Please be aware the officer is also instructed not to initiate communications with you or enter the deliberation room without your consent, except to communicate on behalf of administrative matters such as breaks, meals, the end of the day, telling you that you're going to go home, come back the next day. If an officer must enter the deliberation room, the officer will knock first, and once he's done with completing whatever he was asked to do by me, then he would leave the room, and then you could start your deliberations again. But do not deliberate when he is in the room, he or she is in the room. Once I receive your question or request, I'll go over it with the lawyers, and I'll get you an answer as soon as possible. Please be patient. If we have to get something electronically, you got to give us a minute to put it together so we can put it on the screen so you can come out and see it. Please, if you're in the middle of a debate on a particular issue, do not tell me that you are, Judge, we're 6-6, we're 10-2 on this issue. Can you just help us out a little bit? I don't want to know where you are in your process. The only thing I need to know is either, yeah, I got a question and I'm going to answer it for you, or you got a verdict and then we know it's unanimous. That's the only time. Okay. Now I've come to my end of my charge. Let me just speak to the attorneys for a second. I'm going to take a second. the truth. Can we have our way that we do our alternates? Can we bring that in? No, you're good. We know where you are. Get ready.
Knew it.
Put it- First show at Anna, this is. I want absolutely no responsibility at all. Relates to this. So what Anna's doing is, so that you're aware, is that it just says juror 1 through 16 on some cards, and what we'll do is we spin it, we put our hand in there, and we come up with one. 2026, we're in.
It works. I thought we were playing bingo.
We have just for the special.
Okay, go ahead.
Juror number 16.
Jurors number 16. Okay, keep going.
Juror number 15.
15. Oh, this thing spins well.
Trimming from the top. So they get. Unfortunately, that thing is messed up.
11.
Okay, one more.
So now, that's so
8.
8. Okay. Yeah. Okay. So jurors number 8, 11, 15, and 16 will be my alternates. So right now, just hang out for a second, and we'll talk about that role in a minute. What I want to do is right now is I'm going to swear in my officers. If there's new officers tomorrow morning, then I'll swear in new officers. But I'm going to ask for the officer in the back and also the officer in the front, if you don't mind. Could you just raise your right hand for me? Do you solemnly swear or affirm that you will do your best to keep every person sworn on this jury together in a private place, and that you will not allow any person to speak to them nor speak to them yourself, except by order of the court, and except to ask them if they have agreed on a verdict until they have so agreed?
I did.
Thank you. All right. All right, so next part. I want to give you an idea for the people that will be in the jury room for a minute. I just want to tell you the items that you will have, because you won't have certain items in there. For example, we don't give you the guns in there, or we don't give you the bullets in there, and we definitely don't give you both of them at the same time. So if you want to see the weapons, any one of the weapons involved, you would have to ask me. You have to write a note saying, can we see S whatever? And then we'll give it to you. And if you don't know the S number, we'll take care of it. So let me just tell you what you do have in evidence. S1, which was the photo book with all its subsections, you have that. You will have S2.1, which is a photo from the Caneiro family. You'll have S7. I'm not going to read them all, but I guess I have to. Text messages that you'll have from November 20th, 2018. S8. Well, if you're going to physically have them, I don't think I have to read every one. You'll have S8, S10, S11, S12. These are all records, so you'll physically have all of them. S17, 18, 19, 26, 28, 29.1 through 29.10, 30.1 through 30.19, 33.1, 34.1, 35.1, 40, A and B, 42, 44, 45, 46, 47, 48, 49, 50, 51, 52, 53, 61, A and B, 62, 63, 64, 65, 66, A and B, 74, A, B, C, D, and D.1. Now, did 70, I should go back. So 66 is the Waze camera from the kitchen area and the office area. You'll have a disc of that. If you want to see it, you got to come in here and we got to watch it. 74, which is the body-worn camera of Patrolman Marino. If you want that, you got to let us know. It's in evidence. We'll bring you out here to play it. S76, A, B, C, and D. That's the Patrolman Wankowski's body-worn camera. Again, if you want to see it, come on out. 78, same thing. Patrolman Bernard's body-worn camera. Come on out and we'll show it to you. Then you'll have S93, S94. S96 is the 911 call from Boris. That's 96B. 99 is the CD of Catherine Lucchese's 911 call. 101 is the DVD of the sergeant from Colts Neck, his MVR. If you want to see that, you can come out, we can bring you out. 102, same thing. It's Patrolman Stephen DeCaesar's Colts Neck, his MVR, and if you want to see the gas can at S155, we're not going to put a gas can in there. If you need it, well, we can give it to you.
Keep going.
You okay?
Yeah.
Okay, we're almost there.
Good. Liquid adjustments.
The gas can. Then you'll have 156, 157, 158, 159, 160, 162. It's the automatic knife. You saw that. If you need to see that, you have to tell us. We'll come out here and you can look at it. Same thing. Well, you'll have 163, 164, 166, 165. You'll have 168, 169, 170, 171. You'll have 172. You'll have 173. 174, 175 you'll have. Then we get into firearms. You will not have, but you could see it if you want to see it, is the 9mm. Well, you'll have the barrel. That's 176. 177 is firearm parts. You will not have it. If you want to see it, you can let me know. 178. Is the Pelican Storm case with a knife and flashlight. If you need that, you can ask me. 179 is a magazine. Also, you won't have that. 180, 181, again, that's any guns you won't have. 183, 184, 185, 186, you'll have those. 187 is also a handgun. 188 is a handgun. You won't have these. 189, you won't have them, but they're in evidence. 190, 191, 192, 193, 194 is ammo, the Fiocchi ammo. If you want to see that, all you have to do is tell us. 195, 196. Again, if you want to see those things, all you got to do is ask. You'll have 214. 222 is the 6 magazines and 11 unfinished lowers. If you want that, you're going to have to ask us for. 230. You'll have 231. You'll have 232, 33, 234, all the way up to 242. You'll have all of those. 256 is the 911 call from Dennis Kapora. If you want to hear that, you got to come out and ask us for it. You'll have 261, 262, 263 is the DVD of vehicle surveillance videos. If you want to see any of the car, the alleged car leaving the Tilton address, and then any of the videos at Colts Neck, you're going to have to ask us for it. You'll have 264, 270, 270.1, and again, more surveillance cameras. If you want them, you got to ask for it. You'll have emails from 273, 274, which is the iCloud iCloud emails that were read to you. You'll have those. You'll have scene diagrams in 285. You'll have items from the autopsy. You'll have all those. That's 299. Through 329. You'll have 338, 347, this text messages between Block and Paul Caneiro. You have 375, which is a Verizon lost power notification. 391 is the ways of the garage north shelf. If you want to see that, you'll have to come out and ask us for it. Phone calls, the 3 phone calls were played. They're in evidence. 392, A, B, and H. If you want to hear those again, you have to come out so we can play them. Generator 405, photo depicting the electronic panel. Those are in evidence. You'll have those. Any photos you're going to have, which is 418, 419, 437, 467, 474. You'll have all those. You'll have photos from the defense. They have a bunch of photos that they're going to give you also. That's marked D1. And there's a large number of photos that you're going to have in your possession. You're also going to have the group text between Ben, Keith, and Paul, D55. The Canada Life full payment breakdown, D64. Body worn camera again from Marino. If you want that, we'll have to bring it out so you can see it. Marino, that's D71. A photo of the refrigerator. You'll have body worn camera again of Redmond. You'll have to come out for that. That's D106. Video of 44 Willowbrook at 8 p.m. That's D114 if you want to see that. We'll bring it out. D122 is an email between Paul and Sense. You'll have that. D140, 141 are allele charts from Bodie. You'll have those. You'll have certain PowerPoint slides from Carl Reich, pages 2, 10, 11, 12, and 13. Not the entire PowerPoint, but you'll have those pictures, and you'll have those in your possession. So I only try to tell you that because so that you have an idea of what you do have. I can't give you the list because the lists also have things on it that you don't have. So I apologize that I can't just give you that. Okay, so now here's what's going to happen. It's now 4:30. So now you're going to say to me, really? We just done all this and now we got to go home? We don't keep you overnight for when you start deliberations. We normally finish the day somewhere between 4:30 and 5. But because it's been an extremely long day for all of you, and a ton of information, and out of respect for all of you guys now, what I'm going to do is I'm going to send you home for the day. However, this is how it's going to work tomorrow morning. Tomorrow morning, as soon as all 12 deliberating jurors are here, if it's 8:02 and you're all here, Amor is going to bring you up. He's going to put you in that room. In that deliberation room will be all of the evidence that we just discussed. So you're going to go in there and you get started. There's no more wait. In that room will also be 12 binders that will have all of the charges laid out for you. So you'll have your verdict sheet, you'll have your binder. It'll all be in one little binder for you, so everybody can open them up and talk together as a team to figure it out. And you'll get started. My 4 deliberating jurors, you will be taken to another room very close to this room. Why do I do that? I'm not going to leave you downstairs. Here's why. If something happens to one of our 12, we take the 4 numbers, when we bring you back, and we then put it right through this lovely machine again. We pick one out of the 4, random, and then that one would go in to replace one of the 12 that couldn't continue. But we need 12 to be able to decide. Understand, if you're not, for example, if somebody doesn't come in tomorrow or whatever that is, then, for example, if you're one of the 12 deliberating jurors, I'm replacing you at this point. And we're not, at this point in time, we don't slow down. Here's what I'll tell you. Tomorrow, you have as much time as you need. You have all day if you want it. Probably, if for some reason at 5 o'clock or so tomorrow, if we're not done, fine, no problem. What I do is I bring you back on Tuesday. I don't bring you back Monday because Monday's the holiday. So I don't want you to stress about time. You have as much time as you need to be able to do whatever that you need to do. So with that being said, though, you have everything, but you can't start yet. Tomorrow morning, you'll start first thing, and you go as long as that you need. So thank you. It was a long day. It's a long 2 days for you all. And I'm beyond thankful. And I'm watching you, and you guys have been wonderful. Probably the best jury that I've seen, and I've been doing this for a long time. So I'm beyond thankful for everything that you've done, your attentiveness, and we'll get this going tomorrow morning. So we'll bring you downstairs. You're gone for the day. Leave your verdict sheets exactly where they are. We'll take care of that. We'll pick them up from you. You don't have to try to do anything with that. We'll get you out of here, and then we'll see you tomorrow morning. So as soon as we have all 12, we're bringing you up. You will not see any of the attorneys tomorrow morning. You will not see the defendant tomorrow morning. Then at this point in time, it's all about you. If you're in the room, you do your thing. The only time you're seeing any one of us is that if, for some reason, you have a question or if you have a verdict. Okay? All right. Thank you all.
Judge, very quickly, if we could just approach.
Okay. Sorry. If anybody has to go in there, go ahead, just in case you have to use the bathroom or something. Sorry to you, because I forgot to bring this up in front of everyone. So, when if a verdict comes in, because you're seated in juror number 1 seat, I would like to make you the foreman. Your vote has no more power or less power than anyone else. Maybe you would start the deliberation process tomorrow morning. But my question to you is, would you feel comfortable as the foreman as to when the verdict is read, if you do reach a verdict in this case, would you be able to do that for us?
Yes.
Okay, any issue, you comfortable? No. Okay, great. You will then be our foreman. All right, thank you, sir. As soon as they're ready, everybody can start to go.
I was just thinking everything had to be marked by hand, evidence. So you should start here. I'll go get the other stuff.
Okay.
For the record, we're giving you the updated charge that cleans up the issues that we had. Yes, please. Thank you.
If you need more than one, I'll have another one back there.
And I'm just going to ask for you to work with the attorneys to change the markings on all the labels so it says EB on it.
Yeah.
Okay.
You want that done tonight?
Yeah, because everything has to be done in the room, and then the sheriff's department, we have to lock it. We have to put a note on the door that says no one to come in, no cleaning people, no nothing from now on. So you guys, if you need to change the books and stuff, go ahead. You guys can get started.
I did it already.
There you go.
Yep.
So why don't you collect those sheets and you guys can start putting them in there. So as soon as they walk out, you can